Yay. All persons having anything to be fully audible to justice of the appeals court now sitting in Boston Bar within the Commonwealth. Draw near, give your attendance, and you shall be heard. Once in the Commonwealth of Massachusetts, this court is now open. Please be seated. Good morning, Your Honor.
Good morning. My name is Vicki Henry, and my pronouns are she, her, and I'm your panel chief for today. I'm delighted to be joined by Judge Smyth on my right, pronouns he, him, and on my left by Judge Toone. We have 6 cases on for this morning. We'll hear 3 and then take our mid-morning break and hear the remaining 3 cases. Each side, as usual, has 15 minutes per side. For better or for worse, we do not have rebuttal in the appeals court. I can assure you, although it seems like every month people don't believe me, we have read your materials. In fact, we are quite familiar with them, and many attorneys leave here thinking, my God, they knew my case better than I did. So, with that said, I would encourage you to get to the heart of your legal arguments, because the 15 minutes goes quickly, and we are almost always, and I can assure you today, we will have a lot of questions for you. So, and we want your answers to those questions. So with that said, I'll call the first case, 2024 P9112, Commonwealth versus Melvin.
Good morning, members of the panel.
Could you go to the microphone because it helps with our recording, please? And good morning.
Good members of the panel. May it please the court. I'm Attorney Scott Bratton, and I represent Raymond Melvin. Mr. Melvin is before the court appealing the denial of a motion to vacate a guilty plea under Mass Criminal Procedure Rule 30 for a conviction for operating under the influence, where there was a breathalyzer that he submitted to in violation of the court's holding in Commonwealth versus Hallinan. As you know, the Hallinan decision, it struck down all breathalyzer alcohol test 9510 readings between June 1st of 2011 to April 18th of 2019. Mr. Melvin, he took his breathalyzer on October the 28th, so he fits within that time period. And
so in Hallinan, she had been unable to complete the field sobriety test, and here your client was unable to successfully complete
yes,
them, correct?
Your Honor.
And yes?
Well, I would modify the court's opinion on that. I would suggest that Mr. Melvin, reading the police report in the record appendix, he actually did reasonably well on the field test. There were only 2 field tests that were applicable and given to him in this case. One was the heel-to-toe walk and turn test, and on his first walk out, taking 10 steps heel-to-toe, he did not step off the line. On his return 10 steps, he stepped off the line perhaps twice, and we don't even know if it's an imaginary line or a painted line. But the second test he was asked to do was the heel-to-toe test, and he did not do well on that. He lowered his foot to the ground a few times. But also of importance is that Mr. Melvin at the time was 49 years old. He states in the police report that he had arthritis and that he also suffered from asthma. And he, without the breathalyzer case, without the breathalyzer reading of the .15, it would have been a subjective argument that he would have been making.
So on that point, we have some particularly good police work in this case, because they see this yellow paint on his bumper, and they even go so far as to blow on it to show how fresh it is so that they could contend that he hit the little yellow pole at the drive-through. That was a difference from Hallinan, correct?
That would have been, Your Honor, but that dovetails with my argument as to the conclusive presumption of egregious government misconduct. Because of the .15 being the crown jewel, so to speak, as is referenced in the cases, inducing him to enter his plea, he pled guilty only 30 days after his arraignment at his pretrial conference. And the Commonwealth will argue about the paint being found on his vehicle, small amount of paint. And they also make an argument that...
Could you say that again, about the paint?
That there was a small amount of yellow paint, which would have been perhaps consistent if further investigation would have been done on the paint. But they also make an argument that there may have been video. He was stopped at the drive-thru at a McDonald's.
Right. Do you agree with them that what we should consider is not just the evidence they definitely had, but evidence they could have had?
Yes. In other words, because of the .15, the Commonwealth, I can think that it's reasonable to infer in common practice with a high reading of .15, anything over .08, and as Mr. Melvin sets forth in his sworn affidavit, his lawyer told him to accept a guilty plea, and that would be common practice with the .15. But my point is this, is that because he pled guilty so early on, and the Commonwealth has argued in its brief that there may have been videotape at the McDonald's that would show his operation. There also may have been videotape at the Kowloon restaurant on Route 1 across the street. None of that was further investigated because I think it's reasonable to infer that the Commonwealth was expecting that he would enter a guilty plea because of the .15 reading. So I think we get into a Brady analysis because of a lack of investigation into other potentially exculpatory evidence. Excuse me, Your Honor.
Well, under Hallinan, right, there's a conclusive presumption of government misconduct.
Yes.
But you have the burden to establish that there's a reasonable probability that had the defendant known of the misconduct, he would not have admitted to sufficient facts in this case, right?
Yes.
And at a minimum, you have the defendant has to aver that, right? That's what it says in Scott, that must aver to this fact. And your client didn't do that. He didn't actually say, there's a reasonable probability I would have not pleaded to sufficient facts. He actually says, I think, in the motion for reconsideration, it's not his position that he would have gone to trial absent a breathalyzer result, but rather that he was not afforded the opportunity to consider the other evidence and possible defenses. But that's not enough to establish your prima facie case on the second element under Hallinan. You actually have to say, there's a reasonable probability that I would not have pleaded guilty or pleaded to sufficient facts. So I kind of feel like there's a problem here that you didn't meet like the threshold requirement to establish a claim under Hallinan. Do I have that wrong?
Well, Your Honor, I would respectfully disagree slightly. I think that, as he states in his sworn affidavit for a motion for a new trial, that he was advised by his counsel at the time that he should enter a guilty plea or an admission to sufficient facts because of the breathalyzer. So I think we can... But
he doesn't say, well, and I think I made a mistake and I should not have. He doesn't say that. He just says my counsel told him not to, told me not to, or told me to advise me to plead, and I did. He doesn't say, yeah, I think I should, I wouldn't have. He doesn't articulate any defenses he would have asserted. There's really nothing, there's not much to this motion here, and that's the problem. Usually we see some, well, I would have made this argument, I would have contested these issues, but there's nothing like that in your motion or even the motion for reconsideration.
Respectfully, Your Honor, had he additional time, if it weren't for the crown jewel of the .15 reading, had he additional time to investigate his case further, then perhaps he would have gone to trial. I think that we can infer from his affidavit that he was advised by his counsel not to have a trial.
But don't you have as an obligation to make this kind of motion to vacate an obligation to do some, or the defendant has an obligation to do some investigation now and say, okay, now this is the kind of evidence I would have presented, or this is the kind of defense I would have made? Isn't there some burden on you to actually show what kind of case you would have had?
Well, in the police report in the record appendix, the defendant does mention, Mr. Melvin mentions that he had arthritis, and because of his age, so we can see a medical defense that could have been an option for him, just based on the record appendix and what the trooper wrote at the time of his arrest. So I would suggest that this was a rush to a quick decision because of this .15 reading. And using the Scott-Ferreira test, the factors, whether the evidence of the government misconduct could have detracted from the factual basis used to support the guilty plea. Well, had he known that there was a .15 reading that was not going to be used against him, that would have left open the option for him to further investigate and present other defenses.
So
And
the Commonwealth argues that the absence of an affidavit from plea counsel, because in Hallinan there was an incredibly strong affidavit from plea counsel who said in exactly this kind of case, a little iffy with the yellow paint, but that in a case where you just have field sobriety tests and no accident, that they would strongly recommend someone go to trial. You don't have that affidavit here. Should that make it, they say that's really important and maybe dispositive. What do you say to that?
You know, they do, Your Honor. This court decided this year on January 10th of 2025, Commonwealth versus Dwyer. And in that case, it was the same trial, it was the same judge who took the plea who ruled on the motion for a new trial. And in that case, I do not believe that there was an affidavit of counsel.
Was that also a Hallinan case?
This would be the Dwyer case.
No, I know, but was it a OUI?
Yes, I'm sorry, it was an OUI with a breathalyzer.
Thank you.
But Dwyer, I was on that panel. Dwyer involved a
Yes, you
different
are.
issue because there was a finding of waiver, not a direct application of the Scott-Ferreira test. So that was the basis which the panel
Yes.
reversed that. It wasn't about whether or not there was sufficient
And the-
showing of a reasonable probability. So I think that's a little distinguishable.
I've attached to appellant's brief 2 other cases that were decided on this issue. One is Framingham District Court, and in that case, there was no affidavit of counsel, and that motion was allowed by Justice Kunis of the Framingham District Court. And it makes reference to, indeed, new counsel, an experienced trial lawyer, has expressed an intention to try the case. I think that's where we're at with this, is that an experienced trial lawyer, someone who has tried OUI cases, would have had a triable case, especially based on the facts of this. I think it's important to note that the trooper did not observe any erratic operation or lane changes. Those were called in by an anonymous informant that the identity of which is not disclosed in the police report.
But he says, he's going to get up and argue in a minute, and I'm going to press him really hard on this question of the anonymous caller.
Yes.
That 911 call would have been admissible. What do you say to that?
I would say that that would be inadmissible hearsay. It would not qualify as an excited utterance. I would object to that at trial by motion in limine. I do not think that that would come in.
But the trooper said that the defendant said he had just had 4 beers. There was a plastic cup of cranberry juice and alcohol in the car. There was the evidence about him hitting the pole at McDonald's. And there's the field sobriety tests that I know you have issues with. But so there was quite a bit of evidence here, right? And your client got a very favorable disposition, wouldn't you say?
Well, he received the standard disposition. He
Okay.
received a 24D disposition, which 95% of defendants receive on a first offense OUI in Massachusetts. But the facts in Hallinan are not any more egregious than the facts in this case. In Hallinan, she had bloodshot and glassy eyes. There was an odor of alcohol in the car. She had slurred speech. This was a police field sobriety checkpoint stop. And she seemed, according to the decision, she seemed dazed and didn't notice the trooper at the checkpoint. She also admitted to having three drinks, and she also failed the field sobriety test. So I don't think Mr. Melvin's facts differ that greatly. In fact, I would suggest arguably they're better for him than in the Hallinan case. So I would respectfully suggest that Mr. Melvin has demonstrated a reasonable probability that he would have considered going to trial had it not been for the improper breathalyzer in the reading of .15. It's common practice in the trial courts, as you probably know, that any reading of a .08 or higher, there's a presumption of impairment, and without an expert witness, most defense counsel are going to instruct their clients to take the agreement. And in fact, I would suggest that he has met his burden in this case, and that his motion to vacate the plea should be allowed and the lower court's decision reversed.
Thank you.
Thank you.
Briefly, Counsel, we're going a bit outside the record, but you said about 95% of first-time OUI defendants receive a continuance without a finding, 24D. And continuing on this theme, what does he have to lose by going to trial? Let's say he went to trial and was found guilty. What would the standard disposition be on a guilty on a first offense? Guilty probation, 24D?
He would receive a guilty finding. He could receive actually a continuance without a finding after trial. That's allowed under Chapter 90, Section 24. But he would receive the 24D disposition, 45-day loss of license to 90-day loss of license, a similar disposition had he gone to trial and lost. And in fact, I would suggest that one of the factors in the Scott Ferreira test is the outcome. Would it have influenced the decision? Well, I would suggest respectfully that a not guilty finding, which could have been possible in this case without the breathalyzer, a not guilty finding is better than a continuance without a finding and a loss of license for 45 days and all of the financial fines that go along with it and the programs, the burden on the defendant. So going to trial and taking the chance of winning would be better than taking a plea under 90 Section 24D and a continuance without a finding.
Thank you very much.
Thank you, Justices.
We'll hear from the Commonwealth. Matthew Padalano.
Good morning, Your Honors. May it please the Court, Matthew Padalano on behalf of the Commonwealth. I'd like to follow up on some questions that you asked Defendant's Counsel. To Judge Smith's point, part of the reason why it's required to go outside the record about what is typical in these kinds of trials is because there was no defense counsel affidavit.
Right, but
Sure.
we can't really adopt a rule that says if you've got a great attorney, you're going to win on your motion for a new trial, and if you just have like an average ho-hum attorney, you're out of luck. That can't possibly be the rule you want us to adopt.
Even I would posit that the specific defense counsel that you had would not even be necessary. You could have some sort of expert witness who says, in these kinds of cases, it's common to go to trial.
Well, don't we already have that in the affidavit of plea counsel in Hallinan? I mean, the SJC said this is what this great affidavit said.
On those facts, Your Honor. I believe that it's a fact
But those facts are pretty close. They're not perfect, but they're pretty close to this one. I mean, as I said, we had great police work here in terms of blowing on the yellow paint.
Sure.
But on the other hand, if I were to walk down the block right here and I would look at all of those bumpers and yellow poles going into the garage at Santa Plaza, I bet there are hundreds of marks on there, and I don't think all those people were drunk. People are just kind of crummy drivers, and we don't make them take a tough test.
Sure, Your Honor. I believe that these are intense factual inquiries, and so for those reasons, it's necessary to compare the specific facts to the specific evidence. And
Right, let's go through it. Field sobriety
Sure.
tests. She couldn't complete them. He had, he did better than many, and he's got a medical defense, right?
Sure. So I would posit that it's up to a jury to believe the medical defense, Your Honor. But yes, there are the tests that he failed. There's the cranberry juice mixture. There's
That's not discovered until after the arrest, right?
yes, Your Honor, but I don't see
Okay.
any reason why I wouldn't be able to be brought into trial There's no question as to its admissibility and testimony regarding it.
I mean, you make an interesting argument that you basically, it's not just what you knew, but what you could have known.
Sure.
Right? And I think that cuts both ways because the defendant could take advantage of that. But your problem here is that you didn't have it 30 days after the arrest. And the chances that video is going to exist after 30 days it starts to decrease substantially, if not totally, because most people have a 31-day system at most.
Sure, Your Honor. I don't believe there's anything in the record that says that the Commonwealth didn't have it in its possession at that time.
Nothing in the record that said it did either.
I know, and frankly, that's part of the
So what
problem
do we
with these Helen
presume on
motions.
that? Do we
So I
presume
think
anything?
in this instance, you have to look at what a reasonable person in the defendant's position would have done. The Scott case says that that's the standard. Would a reasonable person have gone to trial in these situations? And so I think a reasonable person sometimes makes calculated risks, but where there's all of these things put together, I would ask the court not to view them in isolation, but view all of these risks together and say that that would have weighed
Right,
against
but
the defendant
that's,
at
so
trial.
then he argues that the Commonwealth cannot in good faith dispute that cases that are similar to this case, or even stronger on behalf of the Commonwealth, go to trial every day and can result in not guilties.
Sure, Your Honor.
Agree with that?
They can result in not guilties, but I don't think that's the
Well, they-
standard here. I think the standard is, would a reasonable person have gone to trial? And that's part of the
But
benefit.
he's saying lots of reasonable people don't, they do go to trial, and because they're gonna, mostly they end up with, especially on a first-time offense, is this a first time?
Yes, Your Honor.
Because Helenan was a second,
Sure.
which we don't really emphasize enough.
Sure.
And so here, he's like, I could have rolled the dice, and that's what the Helenan affidavit says. If there's no accident and there's no high breathalyzer, then he tells people to go to trial because jurors are thinking that guy could be me.
Sure, Your Honor. I believe part of it is that we can't adopt the affidavit in Hallinan as fact. I don't think that's how affidavits candidly work.
Well, he's giving, he's saying this is what a good attorney would have done, and the SJC took that.
Yes, Your Honor. I think moving on from that, the main issue is that there's more evidence in this case than there is in Hallinan. There's evidence of an accident with a safety pole. I mean, like you said, safety poles often have scratches and dings, but in this instance, there was the same, or presumably the
No,
same
I don't know,
yellow
let's
paint.
assume for a moment he hit the little pole on the way into McDonald's, although, as I said,
Sure.
I don't think all of those little marks that you see every time you drive into the McDonald's or the parking garage are because somebody was impaired. We got a lot of bad drivers.
When you have that mixed with the fact that he said he had 4 beers, added to the fact that there's a cranberry juice mixture in the car.
I know, but she said she had 3 beers,
Yes, Your Honor, but in that instance, it was no UI checkpoint.
drinks.
Yeah, in that instance, it was no UI checkpoint. There was no evidence of what the driving was like before arriving at that OUI.
I think we have to assume there was no evidence of erratic driving. That's sort of the point of the sobriety checkpoint. But like, she seemed so dazed, she didn't seem to be aware there was a trooper standing there, and those are usually big people.
Right, Your Honor. And I think in that instance, because it was solely reliant on the officer's performance of those tests and the breathalyzers, the credibility determinations on the officer would have been much more relevant than it would have been here.
So what's your best case that an anonymous 911 call, 'cause I don't know that.
Sure, Your Honor.
That would have been admissible.
I will say, Your Honor, the reply brief makes a lot of good points, and that this should be viewed in the context of what would a reasonable person at the stage of the plea deal do. So it's not that it hasn't been fully litigated. We don't know the status of the 911 caller at that stage. We don't know whether it's anonymous or not. And I think that a reasonable person sometimes chooses not to risk a motion in limine to decide that issue, because if they get a motion in limine that the 911 call could come in, then that might.
Right, but wouldn't a reasonable defendant have, secured all the variables so they would have let that motion play out? I don't think the plea deal would have changed, would it?
So in a practical reality, Your Honor, I've spoken with a couple people who do these OUI cases. Part of why these tend to plea quickly is because you have to go to the RMV after the time has elapsed and have a hearing on your license. So by pleading early, you also secure your license sooner as a practical matter. And so I think by litigating out the motion in limine and things like that, you're delaying when you get your license back, in essence. Are there any further questions on that? I'm happy to.
Yes, this is a more
Sure.
global systemic question, but
Sure.
given the framework that the Supreme Judicial Court set up, does it seem to you that the Commonwealth does still continue to benefit from its misconduct because some percentage of these defendants will not be permitted to withdraw their plea?
Your Honor, I don't think there's any denial that this was egregious misconduct in this case. I think Hallinan and many of the Rule 23s that preceded it all agree that this was horrendous misconduct. I think the issue is the SJC has decided that there is still some showing that the defendant has to make. And that showing is relatively minimal, but it still must be made. And it has to be made with credible evidence. And if there are no questions on the evidence, I'll move to the credibility determinations that I believe the judge made in this instance.
Well, tell me about the showing. Is that the basis of your case now, that the defendant did not make an adequate showing to raise this issue? Because there was no evidentiary hearing, there was decided on the papers. And so that suggests to me that to affirm, we have to find that the judge concluded that there was just nothing in the initial motion that gave rise to a potential finding of a reasonable probability. Is that your position?
Sure. I believe that this is a two-part determination. So first and foremost, I don't believe the affidavit establishes the necessary likelihood that a trial attorney would have recommended going to trial on these facts. The second issue is that I believe, even if the court disagrees with me on that first point, that the judge determined that the defendant's affidavit was not credible. So the relevant language in the affidavit is on the bottom of Record Appendix 36 and the top of Record Appendix 37. Essentially, the affidavit says, but for the BAC, I would have gone to trial, as far as I understand. And then if you look on 39, where the judge makes their ruling, they say the court does not find that the defendant has demonstrated a reasonable probability that but for the misconduct, he would not have admitted sufficient facts. I think that, although it's not explicit, that's an implicit ruling of credibility that this court should adopt. And the Bell case and the case that cites Ridge stand for that proposition.
So let's assume every factor in this case was exactly the same as Hallinan,
Sure.
except that the defendant did not submit an affidavit of plea counsel, say because plea counsel was deceased.
Sure.
Do you think that the judge could then deny that motion?
Your Honor, I think that the defendant could go out of their way to find another way to submit that evidence, an affidavit of a...
Well, what if they didn't have a creative, energetic counsel
Sure, Your Honor.
and they just didn't submit one?
I think that the defendant could still say about what their... Your Honor, I think it would,
And I'm not
it would be a
asking
closer
that. I'm
call.
asking, could a judge say, they don't have an affidavit of plea counsel, there was one in Hallinan, that makes the case different, you're done?
Sure. Your Honors, I don't have the case in front of me, but I believe there's a case that says that the lack of affidavits can be relevant to credibility determinations, and I think where the defendant doesn't say why they can't get a defense counsel's affidavit, that's extremely probative into the credibility issue. And on that point, Your Honors, from what I can tell, the defense counsel is still practicing to this day, and there's no evidence as to why his affidavit could not be obtained.
So, you go.
Should we be less deferential to the credibility determination considering there's no hearing?
Your Honor, as far as I can tell, the Upton case, and I believe it's page 162 in the Upton case, stands for the idea that you can have these credibility determinations without an evidentiary hearing. There's not much language in the law as far as I can tell on that point, but as far as I can tell, it's not an issue of fact that, you could determine in the same light. Where it's a credibility determination, it's not necessarily that you are not able to make those determinations, it's that the proper person to do them is the motion judge in that instance.
How do you make a credibility determination without a hearing?
I believe just reading the facts, looking over what the defendant has presented, and determining that it's self-serving and not trustworthy. Frankly, I think that's what the motion judge did in this instance.
Because there was going to be a hearing here, right?
It's frankly a bit confusing as to what happened.
It sounds like the Commonwealth wasn't ready, and then it got continued, and the judge was just like, well, I'll just rule on it.
Yeah, frankly, Your Honor, I can't make sense of this record, but it's fairly clear that there was not an evidentiary hearing, and so I think we have to view it in that context.
I know there are cases talking about self-serving affidavits. It just seems hard to understand how we can review, the judge didn't actually say that, but even if we assume that he felt it was a self-serving affidavit, like how do we possibly review that? Because there's no hearing, there's no.
Well, and frankly, from what I can tell from the Bell case and the Ridge case, this court doesn't review credibility determinations. I mean, they say we accept credibility determinations made, especially where they were the trial judge, but that especially, as far as I know, is not limiting on the first part. And the Bell case has a specific cite just for that first part of the sentence, seemingly implying that that sentence can stand alone before the comma.
Well, I'll have to read that. I thought if their determination was based just on a videotape or just on the papers, that we were de novo, but you're saying it's not the case.
That's for factual determinations, and I believe credibility determinations have a different standard, which, as far as I can tell, is this court accepts those determinations. And obviously, the facts are, what did the defendant say? The credibility determinations are, can those things that they say be trusted? And again,
Is there a reason why the trial court would be in a better position than this court if the credibility determination was made on the papers?
Sure, Your Honors. I don't believe it is about being in a better position. It's that at a certain point, credibility determinations have a sense of finality to them. If the reviewing court could make a credibility determination, it would essentially give every defendant or anyone in any case a second bite at the apple for a credibility determination. Every credibility determination would be susceptible to review.
I mean, we're all kind of guessing that the judge, or assuming that the judge made a credibility determination, because he didn't say that in his order. All he says in his order, the court does not find the defendants demonstrated a reasonable probability. So it's really hard to infer that a credibility determination was made. I read this as sort of saying the defendant didn't meet his threshold burden to plead a reasonable probability, but to sort of say, well, he did, but the judge found it self-serving and not credible, that seems like another leap beyond what this record would
Sure, Your
support.
Honor, and I agree that it isn't explicit. However, I would say that given that the defendant's affidavit was relatively bare bones, there's only really one sentence at issue, and that is, I would have gone to trial, and that sentence implicitly discredits that one sentence that is sort of the crux of the defendant's argument. And Your Honors, I would just, because my time is limited, move to the issue of disposition. Obviously, the Hallinan case puts the Commonwealth in a tough position because the Hallinan case, they received an impossibly good outcome, given that it was a second-time OU offense and they shouldn't have been able to give that disposition. But here, there were 2 civil infractions that were dropped. I don't know the defendant's financial situation, but civil infractions could be relatively large. As I stated earlier, this begins the clock of when the defendant can reasonably get their license back. And I would also ask the court to view the disposition in the context of the other evidence that I've already discussed as to why the Commonwealth's case was strong and why it would have been unreasonable to proceed to trial.
Just briefly, I think the defense bar may raise as an issue. I mean, practically speaking, the first conversation counsel has with defendant is, look, you're twice the limit. You should probably just plead guilty and get your license back. It should be more than that, but he's twice the limit. Is that not a crown jewel piece of evidence? If the jury hears he's twice the limit, they're just guilty?
Sure, Your Honor. I believe the Hallinan framework sets up an analytical way of looking at these cases, not just that it is the crown jewel, but from that. And I will also point out that the breathalyzer test in this was 0.15, which is less. Obviously, it's still above the legal limit, but it could have been susceptible in a way that the Hallinan one was not to cross-examination or the like. And again, that's why having a affidavit of defense counsel or any OUI attorney would be helpful here.
But it's double the limit. What if it were 0.3? Same scenario. This case, what if just switch out the breathalyzer to a much stronger, like 0.4?
Sure.
You think it's the same analysis?
I think it's the same analysis with it being a stronger, more inculpatory piece of evidence. And again, that's why these are terribly fact-intensive inquiries, that we need someone who practices these regularly to decide, or to at least state for the court that it is relevant, and that it is the crown jewel, as you said, and as Hallinan said. If there are no further questions, I'd rest on my brief.
Thank you very much. Our second case on for today is 2024 P525, Commonwealth versus Thomas Patrick Bleakney. we will hear from the Commonwealth, I think, first.
Good morning. May it please the court. Julianne Campbell on behalf of the Commonwealth. I'm here today asking that this court vacate the trial court's allowance of the defendant's motion to dismiss with prejudice because the Commonwealth did not impair the integrity of the grand jury proceedings in this case. I think if I could just start by, there's a few points of law I'd like to address, and that is, as there's obviously 3 categories of evidence that I outline in my brief, but the standard here, and I think where the judge erred in part, is that dismissal is appropriate when the Commonwealth knowingly or recklessly presented false or deceptive evidence, presented for the purpose of obtaining an indictment and probably influenced the grand jury. And here the judge found that the prosecutor recklessly presented false or deceptive evidence. And again, that was with respect to 3 categories of evidence.
Does what the Commonwealth need to do vary in a case like this where the person is recovering a memory as opposed to, say, where the person knows, I'm sticking in the realm of sexual abuse of a child, where the person knows the whole time but just hasn't told yet?
I don't think so, and the reason, and this is part of what I wanted to address in discussing the reckless standard, is that under Hunt and Ramos, reckless disregard for the truth means without reasonable grounds for believing the false statement to be true. And that's where I would suggest that the motion judge erred in how she approached all of the categories of evidence, because there is no basis by which any of these 3 categories of evidence that I refer to in my brief, that there's any suggestion that a prosecutor acted without reasonable grounds for believing the evidence that was
Would you
elicited.
just go through the 3 categories?
Certainly,
Your
Your
Honor. On
Honor.
the same page?
And so, as I outline in my brief, I refer to it as the victim's statement. I'll refer to her as Jane, regarding suffering from UTIs as a child. There is the category of evidence related to Jane weeks prior to recognizing the defendant as her assailant. Weeks prior in a conversation with her mother, she asked essentially, what about Uncle Johnny? And then the 3rd category I referred to as Sergeant Prouty's testimony about the defendant's flat affect or what he described in his opinion as a flat affect during the interview, which was introduced as an exhibit for the grand jury with the means to play that during their deliberations.
What does that mean? I'm sorry. What does that mean, means to play? I mean, usually if there's video evidence and you have a fact finder, you play the evidence. You don't just leave them with a video machine and allow them to decide whether or not. I mean, that's very odd to me. Either it's played to the grand jury or it's not, and you can't really say.
So I respectfully would challenge Your Honor's thought on that, because there is no requirement that I'm aware of, whether in grand jury or at trial, that an exhibit be published to finders of fact. Now, often parts are, but in fact, the Guide to Evidence, which I know is not a binding authority, but it does refer to cases, suggests that a summary evidence, for example, is appropriate at trial, and so portions of video may be admitted when full video is available. And so it's not for, there is no requirement that any type of evidence ever be published to a jury. And so here, the record is clear that the video was introduced as an exhibit. The record is clear that a laptop was available. And certainly if the grand jurors had technical questions, as they could at a trial, regular jurors, they could ask for assistance with the technical means. So we don't inquire as to what occurs during deliberations and how jurors or grand jurors view evidence, weigh evidence, but the fact that an exhibit is entered is sufficient for determining things like whether probable cause was met or whether someone is guilty beyond a reasonable doubt in a sufficiency context.
Is there any indication they watched it? Like, in other words, the video's an hour and then an hour and 5 minutes
There's no
later?
timestamp on the grand jury minutes, Your Honor, but again, I would suggest that we don't We don't look into what happens during deliberations when we look at sufficiency, for example. We just note that the record supports or does not support the outcome.
What was or could be the purposes of having the police officer testify that the defendant's affect was flat?
So, Judge, I think with respect to how an interview is conducted, which is what Sergeant Prouty testified to, a person's demeanor is absolutely relevant during an interview, and I would suggest that...
No, I agree the demeanor is relevant. I'm asking about the police officer's characterization, because you could just play the video and let them see whether the affect was or was not flat, but you specifically had this officer say it was flat.
And so what I would suggest is twofold. One, that there's a factual error here in the judge considering this as repeating the same error at the first indictment. So I am suggesting that's a factual error because, as I outline in my brief, the first officer's testimony at the first presentment, I would suggest, is somewhat egregious in that she says, in 20 years, I've never done an interview like this. He was completely abnormal. He was
Right,
weird.
this isn't that bad. That's not
No,
an
but it's,
endorsement.
but what I'm getting to, Your Honor, is that the factual finding by the first motion judge is that this person, as I outline in my brief, was calm and responsive and a flat
They
affect.
didn't use calm. I mean, if you're talking about water, calm and flat can be the same thing. When you say a person's affect is flat, is there any implication other than something wrong with that person?
Yes, Your Honor, it's that he's lacking in zest, vigor, he's not defiant, he's not...
Right, that's not good.
But it is consistent with the judge's, former fact finder's description. And moreover, my second point, so I first contend that that's a factual error that the judge made, that this is repeating the same error. And my second point is it's a legal error in that it is unlikely to affect the outcome of the grand jury, in that the grand jury had as an exhibit the video themselves to view. And this court does not go into
But
the...
you'd be in a stronger position to stand on if you'd have played the video.
I don't disagree, Your Honor.
Okay.
It
But
seems
we
like it's not the same error, but it's the same category of approach of, instead of playing direct evidence of how the defendant reacted to being asked this question, presenting some officer's characterization. Now, it wasn't as egregiously bad as the first characterization, which was just outright false, but it certainly doesn't seem as probative as actually just playing. If you think this is pertinent to the grand jury's determination, play the video and have them make their own judgment.
I'm not disagreeing that playing the video would have been the best course of options here. What I am suggesting is that the video is an exhibit that the grand jury could have and would have considered, and we don't inquire into their deliberations and how they weigh evidence. And moreover, I'd suggest that the lay opinion of someone's demeanor while they're speaking to police is absolutely relevant, and it's not inappropriate because this is this person's opinion of what someone's demeanor is. We elicit that type of testimony all
But
of
you're
the time.
not soliciting it as a layperson. You're soliciting it as here's a person who interviews lots and lots of defendants.
That's not how this was presented, Your Honor. I agree in the first presentation that was inappropriate. That is not how this was presented in this case. And at no point was this officer labeled as any type of expert in any type of area.
So, does the court need to see this interview to be able to rule on your appeal?
I don't think the court needs to. I'd be happy to have the exhibit transmitted if the court would like that, and I can certainly do it as of today. I can seek to have that done, given that the ultimate determination is whether the grand jury would have found probable cause, and it is an exhibit, and I would suggest I'd be happy to transmit that to the court. I don't think it's required because of, as I've outlined in my brief, I think the judge made a factual error in saying that this was the same error that had happened just based on the transcripts themselves and the prior factual findings, but I'm happy to transmit that given it was an exhibit.
Do you think when the police officer testified that the defendant's affect was flat, do you think he meant normal?
No, I think he meant lacking in any type of excitement, vigor. I mean, different people speak differently. And I think what's key here is that this officer didn't say he spoke abnormally. It's the same as when,
But do you think there was a negative implication?
no, Your Honor, because it's no different than in an OUI context when someone says, an officer opines, well, their speech was slurred, and on cross-examination, they're asked, well, you don't know how this person speaks daily. You don't know what their normal speech patterns are or if they have a medical opinion. No one said this was abnormal. And so I don't
The judge said, listen, using the word flat implies an odd emotional reaction to the alleged charges.
And that's what I suggest is factual error, because given the definition of flat and even flat affect, that's not true. Some people speak in a monotone tone.
I tend to think of like psychopaths being flat, in their response to, not and I guess, I don't know. It seems like, but I take your point that it's not as bad. Can we talk about the UTI
Certainly, Your
evidence?
Honor.
Because that seems really, it was false information presented to the grand jury, and it does seem very, if it had been true, it would have been very probative of probable cause, right? Because here's the complainant saying, I only got these UTIs during the time of alleged abuse, and then after the abuse stopped, I didn't get them, right? And that was completely untrue. And so I'm trying to integrate the standard of recklessness, and I know you say it's reckless disregard for the truth. What obligation does the Commonwealth have to talk to the original source of this information, the mother, or to go make independent review of medical records and actually determine whether there's any basis to that? Because this is very probative testimony that was presented.
So I want to put a pin on that and get the facts and then answer his question. So is it correct that the Commonwealth took no steps to confirm the UTI timeframe prior to presenting the UTI?
Yes.
Okay, now go to his question.
And so I agree that it was obviously elicited because the prosecutor felt that it was probative information. I'm not disputing that. But I think it needs to be carefully analyzed. And the reason I say that is because ultimately, months later, it was determined to be an inaccurate time frame of the UTIs. And months later, the mother, who did not testify in grand jury, came forward and said, I actually have medical records from 18 years earlier. What's important, though, and this is why I suggest in my brief that the SJC cases Washington W. and Reddington control, is that a grand jury may rely on hearsay, and inaccurate testimony made in good faith does not require dismissal. That is black letter law, and the reason that I say that is because what Jane said, she is clear in her testimony that it is not her independent memory from 18 years earlier that she had UTIs. She explicitly says, my mother told me I suffered UTIs at that age.
Well, I'm going to push back on that a little bit because it was not presented initially by the prosecutor in that way. The question was, and do you recall now in retrospect, or have you heard that you have been having any difficulty with your private area, right? So it was presented this way to sort of encapsulate both direct
Or hearsay.
recollection or hearsay, right? And then there's a little bit of a clarification.
The next question.
Yeah, but then she says, no, my mom told me. But previously, the complainant had said, yes, I had the UTIs, yes, I went to the doctor, yes, it was unusual, yes, it stopped. So it's when she says, no, my mom told me, it's not altogether clear as to whether the mom was telling her each part of the prior things that she testified to. It certainly seems like a better approach for the prosecutor would have been like, do you have any direct recollection of having medical conditions? No. Okay. Have you been told anything by anyone else? Right. To frame it that way would have been a lot clearer for everyone to understand the weight that this evidence should be given, particularly since, as you say, hearsay testimony is allowed. But I feel like there's some obligation on the Commonwealth to sort of frame hearsay evidence clearly from the outset. Do you agree with that?
I think that is fair to say that the Commonwealth should frame it as hearsay. My position is that here, while better work may have been done, the question asked, do you know or did you hear? And then the follow-up, the very next question is that your memory or were you told that? And she says, my mother told me that. And the grand jury themselves were free to ask clarifying questions themselves, and they did not. And so I think it was an error of law, first, to use that as a basis of dismissal when there is black letter law that inaccurate hearsay testimony is not a basis for dismissal. And secondly, There is no, and this I recognize the court may disagree with, but as far as I know, under the law, there is no obligation that this be vetted prior to grand jury process. And the reason I say...
Finish your...
The reason I say that is because the grand jury process itself is an investigatory body. And so it is critical that this evidence made it to the defendant and that he's armed with it for trial. But at this stage, it is not on the Commonwealth to necessarily know, and I don't really think it's reasonable to expect that there would be medical records from 18 years prior. Thankfully, there are, and this was clarified, and the defendant can impeach both the victim and the mother at this should it go to trial. But the grand jury process itself is investigatory. And so with that context, this testimony does not violate any rules of law.
So in the context of a recovered memories situation where the victim is piecing together information and it seems that the Commonwealth, well, let me back up. What was the purpose of putting in the UTIs? Wasn't it to have contemporaneous corroboration?
I don't think it's contemporaneous. It's clear that she's referring to events 18 years earlier throughout and that she had
But
difficulty
that's a contemporaneous fact.
Right, but there's no, but the Commonwealth doesn't try to offer any corroboration as this was proof at that time. There's no, I think it speaks for itself that it is at the victim's representation that her mother told her about this happening 18 years earlier.
Right, but the purpose of that is that there was a objective at the time, that's what I mean by contemporaneous, proof something was happening, right? You didn't put it.
I don't know that it's proof. I think it's suggestive.
Randomly.
I agree, and as I said, I think it's probative, and I think it's suggestive. I don't think it's proof, but I think it's one thing the grand jury considered.
I mean, the bottom line question is, how is it not reckless in the context of recovered memories? I'm not talking about other victim testimony, but in the context of recovered memories where she's casting about trying to figure out who allegedly did this. How is it not reckless to not just do a simple check?
What I think Your Honor is suggesting
before you bring the whole weight
is...
of the Commonwealth against some person?
Well, again, Your Honor, it's twofold here. One, I think saying that should have been done in the absence of law that I am aware of and that defense counsel has pointed to, in the absence of that law, I think at best this is negligence. Sure, better work could have been done, but negligence is not a basis for dismissal, nor is it a basis for dismissal with prejudice. And that's what I'm pushing against, Your Honor. I certainly think better work could have been done, but there is no obligation, and the Commonwealth and the grand jury is allowed to rely on the sworn statements of its witnesses.
So you are obviously arguing that the judge was wrong to dismiss, but if we conclude that the judge was right to dismiss, did you argue that it should be without prejudice?
I do.
I don't think I saw that, but.
So, Your Honor, my argument is essentially that if each of these in and of themselves are not a basis for dismissal, and where prejudice is the most egregious sanction, and my argument is that this is not even recklessly presented, the dismissal with prejudice is inappropriate. And so I apologize if that was not clear within my brief, but it seemed in reading the judge's opinion that it was the amalgamation of all of these three instances coupled with, well, Commonwealth, we already gave you a second chance. And the thing is that this does not repeat the same errors as the first presentation, and I'd suggest that each of the errors themselves are not a basis for dismissal, both whether because of an error in law or an error in fact, and so as such, prejudice was wholly inappropriate in this context.
Counselor, the elephant in the room, though, is there are two Superior Court judges have essentially found your office has a pattern of deceiving the grand jury. So when you're talking about these isolated episodes of evidence in the last indictment, these judges are looking at prior presentments as well. And how much should that weigh in our determination of whether there's egregious conduct here?
So, and I think that's a fair question, Your Honor, and especially given that this was the second presentment, but my response is that the idea of a pattern suggests a similarity in conduct. It doesn't suggest at any time, well, if a Commonwealth, a DA's office has several motions to dismiss for grand jury impairment, that every time there's impairment, that warrants a dismissal with prejudice. And here, as I've repeatedly said, the error is not the same as at the first presentment. And so I don't think it's...
Well, the error of not playing the recording for the jury is the same.
There is no law that requires the Commonwealth to play or publish an exhibit, and that that cannot be a basis for dismissal.
No, but not playing it and having a witness comment on it is different than asserting there's no law that you need to play it.
And again, my response is that having a witness describe a demeanor is not an error of law, and is not inappropriate, and is not a basis for dismissal. And it is not a requirement that the Commonwealth actually play or publish an exhibit, whether at grand jury or at trial. And so I certainly acknowledge better course of practice, and what that may be involves playing the video. But there is no basis in law for either of those positions to be a basis for dismissal. And so the error, the pattern of misconduct that might suggest prejudice is warranted here is in fact not a pattern.
Just two quick questions. Just to follow up on what you said to Justice Henry, am I right to assume that even though it's not what you want, it's within our authority to affirm the second motion to dismiss, but say it shouldn't have been done with prejudice?
I think that if any one of the findings in which the judge concluded the dismissal with prejudice is warranted, I think if this court disagrees with any of them, that the dismissal with prejudice cannot be affirmed, because similar to the context of a violation of probation proceeding, if one technical error among multiple was found to be inappropriate, this court must remand to the sentencing judge to craft a new outcome.
Okay, but can we say, I'm just hypothetically, it was an error to dismiss the second indictment, but it was error to do so with prejudice?
That, I believe, this court could do.
Okay. And just on the Uncle Johnny evidence, just a quick factual point, because you write in your brief that neither Sergeant Prouty nor the presenting prosecutor were aware of the conversation about Uncle Johnny until months after the grand jury presentation. The defendant says in his brief that the police knew about it, Lieutenant O'Shea knew about it from the very start of the investigation. Is that true?
I believe that is accurate. My ultimate issue with the Uncle Johnny evidence is that as a matter of law, I'd suggest it would not have probably influenced the grand jury, because even had that been presented, the grand jury would have also still heard the response to the name Tom several weeks later, as well as why I suggest it's a factual error that it wasn't a true accusation, but more of a question of who had access to me.
Okay. But someone on the police force knew about it prior to this presentation?
That's my understanding from the record.
Thank you.
Thank you.
Seeing no further questions, thank you.
We'll hear from the defendant, and I hope we can get more on track with time, but we will give you more time if, out of fairness, if you need it.
If I need it, Judge, I'll ask. If not, I'll play it by ear.
Thank you.
Thank you. Good morning, Your Honors, and may it please the Court. My name is Peter McGuire from Benzica McGuire, Sheen and Wood, and I represent the appellee, Thomas Blakeney, in this matter. Judge, Your Honors, I want to pick up on a point that Your Honors had just raised as it relates to the affect question, the flat affect question. Justice Davis in Blakeney 1, which we'll call the initial grand jury presentation here, made pretty specific findings of fact about that. He made very specific findings of fact that isn't to sort of sum up. He said he had a normal affect. He was responsive to the questions and some of the words that he uses. For them to even mention affect, to let alone do it in a pejorative or negative way to sort of categorize my client's demeanor in front of the second grand jury, it plays to the sort of pattern.
It's astounding. We get that.
It is, and it should have been a third rail for them, and they wouldn't have offered it but for the need to provide some corroboration for the ever-evolving memory of their complainant in this case. This is a complainant, and I'm not going to try this like it's in front of a jury, but this is a complainant whose memory in the government's own factual settings here, factual layout here, had changed her story between the first presentation and the second presentation. There were numerous new indictments added in the second presentation. There were new stories that had evolved. So, for example, at the first presentation, something that would have been categorized as a raspberry kiss blowing on the skin was now oral sex with mouth to vaginal area. And it seems that those changes in her story took place up to and including the day of the presentation is what I seem to be gathering from the government's disclosures as it relates to the...
Right, but if she were to have rebuttal here, which we don't, she would get up and say, but that's how memory works, right? I mean, anytime you have a situation where something happened a long time ago and then somebody asks you about it and you tell a little bit of a story and then, once you start prodding the memory, more comes back. I mean, we've all been litigators for years and years and years. We've seen it a million times. Maybe some false memories get filled in there too, but...
And that's the danger here. And it's not more memories filled in the gaps. This is material changes to prior testimony. And I'm not saying they're not allowed to have material changes. I'm not saying we wouldn't be able to argue this if this ever went back to the Superior Court in front of a jury and we can make our arguments about whether it's reliable or unreliable based on the changes in her memory.
Right, but her point, though, is that she's saying we are constrained by Commonwealth versus Reddington and Commonwealth versus Washington W, that basically, even though inaccurate information, really wrong information was provided to the grand jury, but that's okay because they thought it was true when it got presented, and the cases do seem to support that argument. So
I'd like to take on that because I had the same thought when she made that argument before. I'd ask you to consider two types of false testimony here. Let's say the detective is testifying in a murder case, and he says, John Smyth was at the scene, and he saw Bob Jones shoot the guy. This is what John Smyth told me, and I'm presenting this to the grand jury because we're not having Bob Smith testify today. Very well understood, a reasonable, competent adult saw somebody that shoots somebody, told the investigating detective about it, and that's hearsay. If it turns out that John Smith was a liar, that wouldn't be on the government. It wouldn't. Because that's how investigations work. You question eyewitnesses and you can reasonably rely that you can use their testimony even in a hearsay setting at the grand jury. But this isn't that. This isn't somebody saw something. This is a case where they knew darn well that memories were evolving. They knew that credibility was going to be a massive issue. They were taking changes in her story up to, I don't know if they were walking down the hallway to the grand jury room at the time, but certainly in the building that day when the UTI information came out, for example. So I do think more care was due there, and I think they knew more care was due there. And to not provide more care there is our argument that that is reckless, and that's...
What exactly was the reckless disregard for the truth? And to just focus on the UTI statement for it. What exactly do you think the Commonwealth was obligated to do to present that evidence in good faith that they didn't do? I mean, certainly they didn't know at the time.
No, and I'm not suggesting that the assistant district attorney who was presenting the matter knew at the time that it was false testimony. There's nothing in the record to suggest that, and I wouldn't lay that on her without a credible basis to do so. However, what I do think here is that they knew the import of this evidence. They knew what Justice Buckley called it in her decision a bombshell. And they're right. They knew that. And Your Honor correctly noted that before in prior counsel's argument. So they knew. And they also knew that they hadn't heard of it until that day. They also knew that Mom was a phone call away. The medical records were a grand jury summons away. And the notion that it's 18 years ago was...
Still computerized
was in the
medical
2000s.
records, yes.
This wasn't 1948 when there might not have been records or they might have been lost in a flood in the late 70s. These are digitized computer records that pediatrician still practices. So I think that knowing the import of that evidence, knowing the weight and the bombshell nature of it, to again quote Justice Buckley, I think they did have a duty there to make sure that it was reliable, even in the barest sense, even to do the minimum to check on it.
Right, but here's my, okay, so it's bombshell. No. The problem you face, though, is if this young person had just come in and testified that the defendant raped her or sexually abused her, and the grand jury either, believed her or thought, well, he should just go to trial, then this would be an indictment and there wouldn't be an issue. It was only a bombshell because it was wrong.
It's a bombshell because it is the only, aside from the affect thing, which I'll talk about again in a second, it's the only piece of contemporary corroborative evidence that they had. So in these delayed disclosures or recovered memory cases, that is often the problem. The Commonwealth is often left with a complainant and their first complaint witness, and that ends up being the sum and total of their case. They were desperate here to do something else, something more. You saw that blow up and be a problem in the first presentation where Lieutenant O'Shea is found by Judge Davis to have provided materially misleading false testimony here, pretty egregiously so. Multiple times Justice Davis found that her testimony was flat out false. And again, it's another occasion where the video was provided at Blakeney 1, it was provided at Blakeney 2 as well. We don't know if the grand jurors watched it, and I understand the case law doesn't necessarily require the grand jury minutes to reflect whether it was watched or not watched. However, Hunt says, and Hunt, the case referred to by my sister here, says that you can't hide the ball. And that is what happens when you have the detective testify to it and then say, well, they can clean that up later on by watching it themselves. And that was the problem in Blakeney 1, and it's the problem in Blakeney 2, because that's happened twice with this particular case, where there's already a factual finding by a Superior Court judge that his affect was normal. And then to have Detective Prouty mischaracterize it again, when that was already done, is such a third rail here that it's reckless. It really is. And that's how I answer that question.
I mean, if it were just the second indictment and this were the only issue about someone saying it's flat and it turns out not to be, I doubt any of us would be sort of saying, well, that's reckless disregard for the truth. Your argument really depends on the prior, I don't want to say misconduct, but prior events that happened with Lieutenant O'Shea and the mischaracterization, the outright mischaracterization.
And I would say misconduct by Lieutenant O'Shea, but I do think that it is, at the end of the questioning of my sister, you all had asked about a pattern of conduct. And I believe Justice Smith may have asked about it. Isn't this sort of the end of the road of the pattern of conduct? The first instance that we've cited and that Justice Davis cites in his ruling, which I attached in my record appendix, is a case called Commonwealth versus Bat Shelter, where this same police department, in fact, Detective Prouty was the testifying detective, played hide the ball with some data as it relates to a cell phone extraction, and Justice Locke ultimately dismissed that case. And when I made my motion in Blakeney 1, I had asked for prejudice, and I had asked that that be reflective of a pattern of conduct. And Justice Davis declined to do so and gave his reasons in writing at the end of his thing and said, I will give them another chance, and it was only been here twice, that's not a pattern of conduct. And I recall in his oral arguments, I know this is not part of the record, but he said to me, why shouldn't I just do this without prejudice? Why shouldn't I just send this back and let him re-indict it? And my answer to him was, and my answer is the same to you all, because absent a meaningful sanction, they'll do it again. This is the third time that a small town police department on sexual assault cases in a 4 or 5 year period played hide the ball with grand jury with information to the grand jury that had to ultimately end up in dismissals. This is just Situate Mass as it relates to the same detectives and the same DA's office in a short time frame. It's shocking.
You view dismissal with prejudice as essentially a sanction.
I do think it is an appropriate sanction here,
and so just to go back to the question that we asked, if we say, well, we actually don't think that the conduct the second go around was sanctionable, but we don't believe that we think the dismissal is appropriate, that's a possible resolution of this appeal? I
think the court can do that. I think the court has the authority to do that. I did note that the government didn't ask for it as a remedy in their brief, which I found odd. I just note that in the tenor of their brief, it suggests that they don't believe they did anything wrong here. And I think that goes to my point that the pattern is going to hold. That's why I'm urging for prejudice here, because absent a meaningful sanction, the pattern will continue to hold, and no lesson will be learned. And I may be overstating that point, but that's my response, Justice Toone. Thank you.
The judge states in her order that the complainant's first unprovoked belief was that Uncle Johnny was the perpetrator. And the Commonwealth says, wasn't she just asking a question and that the judge's characterization was not fair? What do you say to that?
She brought it to the mom, right? And so she says,
right.
Could it have been Uncle Johnny? I think the quote was, could it have been Uncle Johnny? I think is the direct quote. And mom, who is Uncle Johnny's sister, directs her away from that and then gives my client's name. And that is the sum and total of the identification procedure. That's how my client comes into this. She doesn't recover my client's name. It is given to her by Uncle Johnny's sister. I think that would be an important thing for the grand jury to consider as it relates to whether they believe the identification. Because again, the government makes a lot of hay out of the sort of outsized reaction that the complainant has to the mother's suggestion of my client's name. But his name hadn't entered the fray until mom suggested it, until Uncle Johnny's sister suggested it. Uncle Johnny's name had entered the fray, but not my client's. I think that's really telling of what would be an important consideration for grand jurors in making their determination here.
So they argue that Uncle Johnny's not really relevant because the victim really didn't accuse him, and he was just mentioned in conversation. So could you, you might have just said it, but could you just explain what you think about that?
Sure. I think that the complainant asking if it's possible that it was this person, whether she's formally accusing them or saying this is one of the people I'm thinking of, however the grand jurors want to categorize that, is important, especially important when contrasted with the notion that Thomas Blakeney doesn't appear anywhere in that until Mom suggests it. I think the grand jurors being able to make that contrast would have been really telling for them and really important for them in determining whether that identification, which we were on track to having an overly suggestive identification motion when all this was sort of disclosed in district court and we moved to an Odell motion, that would have been an important consideration there. And I think the grand jury should have had the opportunity. And it was that same Lieutenant O'Shea who misrepresented facts to the grand jury in Blakeney 1, who was the one who, for a year, had that information.
So what do we do with the fact that apparently Lieutenant O'Shea knew about this from the start, the Uncle Johnny piece, but the prosecutor and Sergeant Prouty, who testified, didn't? So what's your argument as to, or do we assume that the prosecution has this knowledge, even though there's no evidence that was shared?
The case law alone suggests that information in the possession of the government or its agents. She is the head of detectives, the lead detective on the case, the testifying detective on the first Blakeney presentation. She conducted the interview in this case. This was her case. So I think that it is fair to suggest that she is part and parcel of the prosecution team here, and compartmentalizing things to escape the need to turn things over, to escape the need to make fair presentations, isn't fair to the defendant in this case. I don't think there's any record here that suggests that the presenting ADA had that information beforehand, but I do think that the lieutenant who runs that who runs the detectives there, or at least ran this case initially, is an agent of the Commonwealth as it relates to this investigation and presentation.
And is omitting this evidence reckless under the Odell standard? I mean, it's not. It's different from sort of presenting evidence in a way that's inaccurate. It's just not mentioning this conversation that happened between the complainant and
what I think was reckless was, and again, this is reckless sort of on behalf of O'Shea as it relates to the team. Yeah. What was reckless is allowing an incomplete understanding of the identification procedure done by the mom, essentially, in this matter, to go to the grand jurors and mislead them. And that's reckless, because in a case where that statement to mom and mom's adoption of my client's name is the sole piece of evidence here that links my client to these issues, to get that wrong is incredibly important.
If she could get back up again, she'd say, well, what it was when the mom suggested him, that triggered a new flood of memories. That's what she would say.
And I'm sure they'll say that if we ever got to trial someday, I'm sure they'll say that. But that's an excuse as to why they didn't present it. It's not a reasonable explanation as to why they didn't present it. So, yeah, well, mom didn't believe it, or, yeah, well, look at the big reaction Mr. Blakeney's name got. It's almost a sleight of hand trick to say, please ignore the fact that we didn't present a full picture of the identification here when our lead detective knew that we weren't.
So let's just, to come back to the standard and the recklessness standard, what's the recklessness?
So it is our position that the recklessness here is failure to even do basic follow-up on the UTI information. There was no urgency in the presentation. My client wasn't held. This was a re-presentation of a previously dismissed case. They had every opportunity to do follow-up, and they didn't. The recklessness is, once again, ignoring Justice Davis's pretty clear finding of fact in Blakeney 1, and essentially counting on the grand jury to clean up that misrepresentation of my client's demeanor by watching the video. And finally, the recklessness was allowing, again by O'Shea here, allowing a incomplete and inaccurate description of the identification procedures as it relates to my client go into evidence in front of the grand jury. And those are really the three areas of recklessness.
You don't disagree with the Commonwealth that negligence is not enough to kind of satisfy that standard?
It isn't. Recklessness is a higher standard than negligence, and I agree with that. I also think that when we get to, because I know I'm running out of time, and I just want to make one more point, when we get to the question of prejudice or not prejudice here on the dismissal, I really think that the key here is the pattern. And I urge the court to look again at Justice Davis's ruling about, which is in my record appendix. I know the court has already gone through it meticulously, and I'm not suggesting otherwise, but that his rulings on that and his note and his concerns about bat shelter, the fact that it's the same department with the same DA's office on the same type of case and the same issue, and there once again, I think that really is where the necessity of prejudice here comes in.
All right, we did let her go over considerably, so if there's anything else I mean, you've done a great, both sides have done a really terrific job.
I looked down at my sheet and I had covered the points that I wanted to cover. The last thing I will.
Twice then.
I do have about 10, 15, 20 more seconds just as it relates to the pattern, because I actually glanced at it one more time and saw a big star on my page. I would note that if you look in Justice Davis's ruling in Blakeney 1, just as it goes to recklessness and as it goes to this pattern, I'd ask you to look at the transcript of how the questioning regarding my client's demeanor and his failure to make denials went in. It's clear that this was an understanding between the Commonwealth and the witness. Like, her question said, when you were doing this interview, was there anything notable about it? It wasn't a throwaway question. It was eliciting that particular response, which leads you to think either the presenting ADA purposefully elicited that response, knowing it was untrue, and I won't go as far as saying that, or she didn't know it was on the video. I'm not sure either one of those isn't reckless. And to see that pattern continue in Blakeney 2 is disturbing. And that is the end of my time. Thank you for your Honor's time.
Thank you very much. As I said, excellent job on both sides. We understand your arguments. The next case up is 2024 P111 Commonwealth versus Jeffrey Flurry. And by the way, as I am now looking on my device here, we have all of your materials on these, so we can look at the record while you're talking. We'll hear from Ms. Peterson first.
May it please the court. Good morning, Your Honors. Jennifer Peterson here today on behalf of Jeffrey Flurry. If I may begin, it's just a preliminary matter with respect to the sufficiency argument. Mr. Flurry, as I'm sure Your Honors know, was indicted for diverse dates between July 1st of 2015 and October 31st of 2017. A careful look at the testimony in this case shows that there's no allegations, because the complainant says she had no memory of being in the trailer where the alleged act supposedly occurred after the family moved to Michigan, which move took place sometime in August of 2015. So at the
Commonwealth says that we can pair up the witnesses, the victim's testimony with testimony from her mother about when they were here in the Commonwealth and at the trailer. Why is that wrong?
Well, certainly they can say that she was there, but they can't say that if the complainant has no memory of any alleged abuse, then there can be no testimony that any abuse took place during that period of time.
Well, she has memory of being raped, right?
Yes, she did.
And she has memory of an approximate age, right? So then why can't the mother fill in the opportunity?
Well, I would suggest that the approximate age was actually what the complainant testified to was 4, maybe 5, and that would put it while she was in Michigan. So that would put it, she just turned 4 in July of 2015. So she would have been living in Michigan during that period of time by her own testimony. But with respect to the fact that if she does not have a memory of this happening at that time after she moved back. And sex assault cases frequently turn on important dates, not specific dates, but important moments in time, a birthday party, a Christmas time, end of school. And this particular one was a move of the family to Michigan, which would be a significant thing in the family's life. And so she specifically said she had no memory of going back to that trailer after they moved to Michigan. So if she didn't go back to the trailer, she couldn't have any memory of being sexually assaulted there. So she couldn't give evidence that she was sexually assaulted.
Counselor, just so I'm following you, the date isn't an element of the crime. You're not saying they didn't establish an element of the crime. You're saying that essentially her memories negate the sufficiency of the evidence. Is that it? Because she has no memory of that time period, then there's no way a jury could find in the light most favorable that...
Yes, if she has no memory of having been raped, then the jury can't find sufficient evidence that she's been raped. No matter whether her mother said she was there and he had the opportunity to rape her, that doesn't mean that there's any memory. The jurors have nothing except speculation upon which to guess, and it's an inference. If he had the possibility of the opportunity to rape her, and she was there, according to Mom, then he could have done it, so therefore we'll find him guilty. I would suggest that's absolutely violates sufficiency of the evidence, Your Honors. The only time window that we can look at would be the July 1st, 2015 to August 31st of 2015, the window prior to the move to Michigan. So that's just as a preliminary basis. As far as other specifics with respect to this, the Commonwealth's allegation was that this assault took place in a bathroom of a trailer home where, with a child who was 2 to 3 feet tall, bent over a toilet. Mr. Flurry is a fairly heavy-set, large man of normal height, and I would suggest, and the toilet was situated such where there was a foot of clearance behind it before one would have to step into a shower stall, and there were 3 feet to the side of it before you would hit a door, roughly. And there was a lot of testimony at trial regarding where Mr. Flurry was allegedly standing while this assault took place. As a preliminary matter, just the height of the child versus the height of Mr. Flurry would make it a physical improbability that this happened the way the Commonwealth alleged it happened.
Isn't that a credibility issue for the jury?
Yes, and I would just say that this goes to the sufficiency of the evidence, and absolutely it's a question of jury fact. But when we're talking about the different dates, the different locations, this all goes into the de novo review, I would suggest, Your Honor. And we would look at this, and this is a case, and I think it's important to look at her uncorroborated testimony, too. Her testimony was not clear. It was not, direct. It was fraught with conjecture and surmise.
What are we reviewing de novo?
The sufficiency of the evidence presented by the Commonwealth in this case.
We're reviewing it in the light most favorable to the Commonwealth.
Yes, Your Honor. But I would suggest that this still, the physical improbability of it goes to it. There was no sound, there was no complaint of pain, the height difference, the spatial difference in the bathroom, and then just the testimony in general. Well, I guess I would go over it, and I guess he would pull my pants. I don't know. I think he told me, but I don't know. She guessed she had to hunch over the toilet. She thinks she was standing, he was standing. She didn't know how she knew put her hands on the toilet, how long it would last. She didn't know. She guessed. She thought, maybe, probably. So there was a lot of conjecture there. Then with respect to the physical exam, there was absolutely nothing, no changes, scarring, anal dilation, nothing that would suggest that she had been sexually assaulted. And I would just suggest that in a life felony such as this, especially where we don't know if the jurors took into consideration, like Your Honor suggested, the fact that the Commonwealth is saying that they can look at what took place after the move to Michigan, even though the complainant did not testify in any way. She literally testified she did not go back to that trailer after she moved to Michigan. And she had specific memories, too. She specifically recalled coming back and visiting her, she recalled the long trip from Michigan to Massachusetts, and she recalled visiting with her maternal grandparents. So she did recall what she did during that window of time when she came back because her other grandmother was sick. But what she specifically said is, I did not go back to that trailer.
You said it was diverse dates. Were they all after the family moved to Michigan?
I don't believe that's necessarily the case. It's unclear what the dates were. So the only window that this could have taken place would be the July 1st to the August 31st, 2015 date. With respect to the intimidation of a witness statute, that statute specifically, says, did she get a gift, an offer, or a promise? Repeatedly throughout her testimony, the complainant said, he didn't promise me anything. And she was specific, and she repeatedly said it. And the Commonwealth...
She also said he promised me, he said he would give me a surprise.
He did, she did. She said that, yes, she said that he would give her a surprise. I would suggest that that is not enough under this statute. This is a 20-year felony. And I would suggest just a kind of a vague, unspecific offer of he'll give me a prize. There was no threat there. And this court has said that the whole idea of the witness intimidation statute is to protect witnesses from being bullied or harassed or somehow bribed. And the Commonwealth cites the Ballard case in its brief, and that case was affirmed here and went up on further appellate review. And the SJC said, that had to do with assault and battery on a family member. And during some recorded calls from the jail, the fiance, the defendant said to his fiance, it'd be better if she didn't testify. Things will work out better in their relationship. Maybe DCF, would get off her case and stuff like that. And the SJC said it wasn't a bribe. It was too vague. They overturned it, and they.
Don't we have to look at this issue, though, in light of the fact that the victim was a 4- or 5-year-old girl at the time, right? And it's to say, well, there wasn't a discrete amount of value on what was being offered, the surprise. I mean, surprises are pretty evocative and powerful to the promise of a surprise to a young child. So I don't know if other precedent dealing with expectations of adult victims are necessarily binding here.
I would suggest that the cases that come under this really don't seem to be of the same nature of this particular case, but I would suggest that there was no real quid pro quo. The whole idea of, don't tell anybody and I'll give you a surprise, there wasn't really a quid pro quo. And she explicitly said he didn't promise me it, and she said it over and over again, she didn't promise. And also, she said she didn't feel like that would keep her from telling. And the Commonwealth cites one thing where she kind of says, well, maybe because of that too. It was kind of an add-on when the prosecutor kept pushing her. But she told repeatedly, I didn't have a problem. I didn't think I shouldn't tell my mom or my dad or my grandma. She didn't feel
I thought
intimidated.
it was okay. I thought it was okay, I guess, for him to be doing it, and I guess I just wanted a surprise. Right.
Yeah.
So she does sort of say this
was... Yeah, sort of. But, she said that once with a lot of pushing from the prosecutor. But at the end of the day, she never suggested that she felt intimidated. In fact, she explicitly said, he didn't promise it to me, and I didn't feel intimidated. And I think going to his actual intent, I don't think the Commonwealth proved any intent on his part because he never suggested that anything would happen to her. In a lot of these cases, don't tell or else something bad will happen to mommy or me or you or whatever. None of that there was no threat. There was nothing there. There was not if you don't do this, then. And I would suggest that if there really was specific intent, why wouldn't he just give her a surprise? Why wouldn't he give her a Beanie Baby that he supposedly had bags and bags of at his house? He never gave that to her. So I just think this is a 20-year felony that the Commonwealth just seems to be tacking on to a rape claim. And at best, they use these type of things as aggravating factors for a rape of a child, as opposed to saying this is going to be a standalone 20-year felony that we're going to charge you with. I just think that this is too vague. There was no promise, and I just think it's not appropriate for them to charge. I don't think did sufficient evidence. They did not provide sufficient evidence that they met all of the requirements under the statute. With respect to prosecutorial misconduct in closing, if I may, arguing facts not in evidence, it was clear that the SANE interview that was done over Zoom was not in evidence. Nonetheless, the Commonwealth told jurors in her closing argument that the, let me get the exact language, that the complainant never said during her Zoom interview that she faced the front of the toilet. There was a lot of back and forth about which was the front and what she meant by the front and what she meant by, whether she was facing the side or the front. Because obviously, if Mr. Flurry had to be in the bathroom, in the stall, the shower stall, in order to be able to assault her, it might raise other questions. And there was a question of where the mirror was, and there was also a question of whether or not it was even possible for him to be on the side, the door side, as opposed to the shower stall side, so the 3-foot side versus the 1-foot side. So this was something that the defense was used as part of the defense, and we're suggesting that it's utterly inappropriate for them to reference the contents as if, which weren't in evidence of this SANE interview. With respect to other things that weren't in evidence, the Commonwealth was well aware that there was an issue where not only were there threats, and threats like that she would kill him, but there was also a knife, Lulu, the knife, that was kept out, and also any kind of information about a civil lawsuit. Commonwealth specifically says there's no evidence that her anger lasted beyond late 2017, let alone into, 2.5 years later into May of 2020. So, but there was evidence, and she specifically asked that evidence be excluded. So I would suggest it's improper under the rules for her to ask that evidence of civil lawsuit that was, that the Robin, the grandmother, lost against Mr. Flurry be excluded, and the knife and the threats and the stuff that went on. And then finally, I'm running out of time, I'm sorry, Your Honors, encouraging the jurors to speculate, and that's the biggest thing. And I think encouraging jurors to speculate, saying just because he had the opportunity to rape this little girl, he must have done it. Mom said that the child was there even though she has no memory. It's clear that he had plenty of opportunities during her visits to the trailer. So I would suggest that encouraging jurors to speculate is improper prosecutorial misconduct in closing, and for those reasons, I would ask that you vacate the convictions against Mr. Flurry.
Thank you very much.
Thank you, Your Honors.
We'll hear from the Commonwealth.
May it please the Court, Thomas Townsend for the Commonwealth. Unless otherwise directed by the panel, I'll address the issues in the same same order as my sister. Beginning with sufficiency of the evidence of the rape, this Court emphatically in the Gonzalez-Santos case a few years ago held that the uncorroborated testimony of the victim is enough without more to establish the elements of the offense. The fact that this 11-year-old girl, she was 11 years old when she was testifying about events that happened half a lifetime ago when she was 4 or 5 years old, that she did not remember that she was visiting from Michigan is not dispositive, certainly. The mother, much older obviously, had clear memory about when they visited from Michigan. And I just want to direct the Court to Volume 3, pages 133 to 134. The mother said Thanksgiving of 2016, they visited from Michigan. January of 2017, they visited. February of 2017, March and April of 2017. And she went on to testify that a lot of the times she sent the victim to stay with the defendant and her grandmother. So that was an opportunity, certainly, for the rape to have occurred. And that 11-year-old girl did not recall specifically where she was living at the time, but she did testify quite clearly to the rapes that occurred at the defendant's residence.
Well, let me ask you about that, Counselor. There was alleged anal and vaginal rapes, correct?
Initially from the grand jury, but we null prossed the vaginal one, so only the anal one went to trial.
And there was testimony that occurred more than once.
Yes, that's correct.
And the evidence, there was a specific unanimity as to they had to agree on one offense as to the anal penetration, the anal rape, correct?
Correct, yes.
And due to the timeline as presented by counsel, due to the inability of the victim to remember, are you saying we should credit the mother but not credit the victim's testimony of had she been there?
No, I'm saying that the issue raised by the defense is not even factually appropriate because the jury can pick and choose which evidence to credit, which witness to credit, and that the absence of a memory by an 11-year-old girl is not dispositive when there's a specific memory by her mother about when they had visited. And there was earlier a question about what was the scope of the indictment and did it encompass the time in Michigan. It did encompass the time in Michigan. The indictment was from July 1st of 2015 to October 31st of 2017. They moved to Michigan in August of 2015, so it was a month after the beginning of the indictment. And they had returned. They were in Michigan for 2 years, and they had returned to the area. So even if we take the defendant's premise that she could not have, or this crime could not have happened while the victim was living in Michigan, the indictment still encompassed a broader timeline. So for that additional reason, that argument is without merit. There was a reference that the victim was 2 or 3 feet at the time, a 2-foot 5-year-old. That only evidence of that is from the defendant's own daughter who testified as part of his case. And she obviously has whatever bias a daughter would have for her father facing child abuse charges. And the daughters also had lived with the defendant in the trailer prior to the victim, prior to this time frame. So she had moved out before this time frame. So, and again, of course, this would have nothing to do with the sufficiency of the Commonwealth's evidence in the Commonwealth's case. That doesn't even factor in. And that the jury was free to reject and properly did reject that evidence as part of the defendant's case. There's an argument that the victim made no sound or complaint of pain. I hope we don't backslide as a society where we reinstitute the hue and cry rule. That has been buried, I hope, for good. There's no requirement that victims of rape run into the streets and cry about it.
But let's turn to the grandmother's anger.
Yes.
Was there any evidence that was suppressed involving 2018 or later? In other words, she's challenging that the prosecutor said there was no evidence of anger beyond 2017.
Right. So
I get, and I have your chart on page 26, I think, of your brief. The dismissal of the small claims suit was in April 2018.
Correct. So the dismissal of this small claims suit was the same general time frame as the assault and battery arrest that was instituted in October 2017 and null pros in February of 2018, and the restraining order, which was instituted.
Good things happened for Grandma in 2018, right? I mean, that the small claims went away, the restraining order went away, and the
everything went away in the spring of 2018. So the prosecutor's argument was there was no evidence of her anger past the fall of 2017, and technically that is correct. She testified that she was a little bit annoyed by being charged with assault and battery, and there was no specific evidence that it continued for another 2.5 years.
Right, but I mean, wouldn't the evidence that she threatened him with a knife impeach the little bit annoyed statement?
Well, that was part of the restraining order. I think that's not a separate claim that the judge erred in not allowing that evidence. The claim here is that the prosecutor somehow had exploited the exclusion of that evidence. I think that was clearly within Judge Callan's discretion whether to include that. So in front of the jury was the assault and battery charge. In front of the jury was the restraining order. And that's the same general time frame that it does encompass the Lulu, the knife incident, and it would encompass the small claims charge, which was dismissed a month after the the restraining order that terminated early. So the prosecutor's point was, and the defendant was free to argue that, human nature, you'd still be angry 2.5 years later, but the prosecutor at the same time was allowed to argue there was no evidence that she was angry past the fall of 2017, which was correct for the evidence. It wasn't an exploitation of exclusion evidence because it was the same general time frame. In other words.
So the defendant, though, says that the evidence, was there evidence before the jury that she was so angry, she said she'd get him back no matter what?
Yes. So that was, there was a defense testimony by defense witnesses that she did. There was a neighbor who testified to that. That was in front of the jury. Now, during direct examination, that witness was very unclear. Speaking about unclear timeframes, that witness was very unclear. That could have been anywhere from 2017 to as late as 2020. On cross-examination, the prosecutor zeroed in on the time frame, and he admitted that it was soon after she had left the defendant's residence. So that would have been in the fall of 2017. So that's what the prosecutor was arguing. There's no evidence beyond the fall of 2017 that she was still angry. Now, the defendant could argue inferences, well, you would still naturally be angry, but the prosecutor at the same time can argue that she was not angry. So I think that is a fair argument, and defense counsel at trial didn't object. So I think the tone, tenor, and manner of the argument at the time did not excite defense counsel enough to object. I think it was clear the argument that the prosecutor was making. And just to segue quickly back, I have a couple more points on the sufficiency of the evidence on the rape. It was almost a verbal filler tick that the victim had. She would use the word guess, like some people would say or
Like.
It's a verbal filler. But when she talked about the actual rape, there was no guessing involved. I direct the court to volume 4, page 44 of the transcript, where she was quite clear. She said, he put his pee-pee into my butt. There was no guessing involved in that. And that line alone is enough to sustain the conviction. And the physical exam, this exam obviously was years later, 5 years after the fact. And the expert, I even included in my brief because it really didn't have much relevancy to the issues raised. But the doctor testified that usually it's a normal exam, especially when we're dealing with anal rape, and especially since we're talking about years later. So there wouldn't be, or unlikely to be, any physical manifestations of it. And for the intimidation of a witness, I mean, on the Bellard case, which I cited as a recent case from the SJC, even though there was a split decision on the court, all justices were agreed that it's the subjective. When we looked at whether something is of value, we look at that's determined by subjective interests of the witness. And here, a gift or the promise of a surprise to a 4 or 5-year-old girl, I submit, would be of value. And in this case, we have actual testimony that she delayed disclosure because she wanted the surprise. So presumably, that's why the defendant offered it, and it worked. It was only happenstance that his name came up during a good night session with her grandmother. Someone had accidentally kicked the Beanie Baby, and his name was invoked. And the victim started trembling and shaking, and she finally disclosed. And at trial, she testified not once, but twice. She was hoping to get the surprise. So I think that clearly is something of value to a young girl. Unless there's any further questions from the court, I'll rest my brief.
Thank you very much.
Thank you very much.
Case is submitted. We'll take our morning recess.
Court, all rise. This court is reopened. Please be seated again, please.
Again, good morning. We're hearing our fourth case today, 2024 P644, Chris Esler versus Curaleaf Holdings, Inc., and others. We will hear from Attorney Rosen, I think, first.
Good morning, Your Honors. May it please the Court. One of the lower court's major errors of fact in the analysis and summary judgment was not recognizing the fact that Mr. Esler's stock was in canceled status for a year. That's never referenced in the lower court's opinion, and it's a critical fact because the lower court found a lack of reliance, a lack of damages, but the reality is Mr. Esler, by the admissions of Curaleaf, was unable to transact on the Global Shares platform, not only during the January, February, March mistakes, but also all the way through to February of 2022. And by then, the stock had been underwater for months.
I wanted to step back and get a bigger picture here, because this is not our typical case, although we do have two stock option cases today. So I think that they're arguing, and I don't think you're disagreeing. It's not the options contract that you say is violated. When you say there was a contract, what was the? I know there's discussion of a unilateral contract and a bilateral contract. What was the contract you say was violated?
Thank you, Justice Henry. The contract that was violated was the offer to use the Global Shares platform, which was accepted. The lower court found both offer and acceptance in its opinion. And then the lower court
I think the court said even if there were offer and acceptance, didn't actually find that there was offer and acceptance.
Okay, thank you, Your Honor. That is true. However, we think there was an offer and acceptance because the email saying we are offering you Global Shares, you've properly accepted that, is in our record. And then the question for the lower court was consideration. We've given you our arguments as to why there was consideration. And there was consideration in a number of ways.
Okay, and that's the next point. Whose consideration? Both parties' consideration?
There was
Just consideration by your client?
Arguably, from the lower court's perspective, there was no consideration given to Mr. Esler or given by Mr. Esler for this, but we disagree. We're appealing that. We feel that...
Let me back up. Am I correct that the defendant never had to offer the cashless Global Shares option?
Never had to, but it did, just like in the O'Brien v. New England tell and tell case, where an employer offers a benefit and an employee gets that benefit, and that's deemed a unilateral contract.
So what was the consideration given to your client?
There was consideration in a number of ways. First, as we learned through fact discovery, on the Global Shares platform, everyone could exercise without having to sign a so-called lockup agreement. So they could exercise more percentage of shares, more percentage of options than they otherwise could have. We showed that similarly situated employees with the exact same option agreement and the exact same lockup agreement requirement no longer on the Global Shares platform needed to do that. They didn't have that restriction. That was both a benefit and a detriment, depending on which way you look at it.
I don't understand. How is that consideration for a bilateral contract? The fact that it's easier for everybody. What difference does that make for consideration?
Because Mr. Esler no longer had that barrier to exercising 100% of his shares. There was no timed restriction on how many you could exercise. And Global Shares, it's undisputed in the record, did not know that there even was a lockup agreement. And other employees...
Let's just, to put it simple, let's say he exercised, so the stock is already out there, it's being traded. And so if he exercised it, he had to pay the company a certain amount of money, but you're saying he didn't have to pay it up front. He would he would be able to sell the shares he owns, so let's just keep it simple. So he would get $15 a share, but he would have to turn around and give about $9 a share to the company. So they would make money.
Correct, Your Honor. And that's another way to look at it, which was brought up by us as well. There was an ease. There was also a timing issue, Your Honor, Justice Toone, with consideration. You could do it within an hour. You could do it within minutes. You didn't have to write a check, wait for the check to be received, wait for the check to clear, have that money in the hands, and then transact. When people want to transact a cashless way, and as the records show, no one did a cash exercise. Everyone did cashless exercises. Why? That's what people want. They want to be able to do it quickly.
But I understand you're extolling the virtues of a cashless option for exercising options. I don't understand why that makes it a contract, right? Just because someone gets offered a better way of exercising stock options doesn't mean then there's suddenly a bilateral contract with consideration. There's a gap that I'm missing here.
Okay, Your Honor, I see it as a contract. I see, would you like this benefit? Yes, I would like this benefit. I accept it. And what's the good thing about this benefit that you're being offered? The good thing about it is you can do it quickly. You can do it without cash. You can do it 100% without a lockup agreement. That's all consideration.
And you're saying he could have given them consideration if he'd have been allowed to use it, because then they would have gotten this infusion of cash.
That's correct, Your Honor. From a unilateral contract standpoint, his ability to perform, his attempt and his tender of performance is the formation of that contract along the unilateral contract analysis. The tender of performance. Now, his tender of performance was frustrated by Curaleaf's errors, but as we've articulated the law in our briefs, that is not.
I don't understand how registering, going back to the unilateral, I mean, none of these theories seem to make sense to me. How does registering for a service and then attempting to use it amount to performance for purposes of establishing a unilateral contract?
Because there's been an offer to take advantage of a new benefit, and then there's the tendering of performance to take advantage of that benefit, and the frustration of that attempt to tender performance, which is Curaleaf's fault, Your Honor, doesn't impair the formation of a contract.
So you argue consideration, I'm pretty much quoting directly from your brief, consideration can be found in the fact that since the lockup agreement was a paper barrier to a cash exercise on the Global Shares platform, Curaleaf allowed option holders to exercise without signing a lockup agreement first, and that this was a second way that there was consideration. I don't even understand the argument.
Okay, thank you, Your Honor. Let me try to explain it. In the original option paperwork, let's just say 200,000, it's around, you have 200,000 shares, but you have to sign a lockup agreement that says you can only exercise 5% a quarter. Okay, so that's the lockup agreement.
Right.
And everybody had that document. Now Global Shares comes in, right? You can now do a cashless exercise. Now we have shown with evidentiary proof in the record that anybody who did and tried to exercise on Global Shares could. None of them had a lockup agreement. None of them had that 5% per quarter restriction, because if they did, they all would have had at most 25% of the ability to exercise 25% of their options around that same time Mr. Esler did, January, February of 2021. So they exercised 75%, 43%, 30%. That would have been impossible on the exact same contract, the exact same lockup agreement.
Okay, but the judge said as of March 10th, 2021, the lockup agreement was executed, all errors with the Global Services account were fixed. You had the opportunity, your client had the opportunity from that point on to exercise his stock options. The stock was not underwater at that point, not for several more months after that. And then your client testified, did you try to exercise your options after March 10th? I don't recall I don't recall if the portal was working. I have no knowledge. I don't recall. So it seems to me like I don't understand the evidence that your client could not have taken advantage of the cashless option at that point after March 10th and not lost his opportunity to make money off these options.
Thank you, Your Honor, for that question. So Chadwick Nelson testified very clearly, and Your Honors, I apologize, every page cite to the record in our briefs is 2 pages too high. Chadwick Nelson I found this out yesterday, and we will refile our brief with Your Honor's permission, but Chadwick Nelson testified, Mr. Esler was in canceled status from February of 2021 to February of 2022. There's an email where he's looking to correct that canceled status. He gives clear answers to deposition questions. My brother asked to submit a supplemental appendix to the court, which Mr. Esler said, I think I could transact by October. Now, he was wrong, but he did say that at his deposition, but that's what the supplemental appendix is about. He was wrong.
You want to file a supplemental appendix here or below?
They made a motion to file a supplemental appendix, Your Honor, that we opposed, yes.
Okay, and
But-
we haven't ruled on that.
Right, but it's of no consequence because Mr. Nelson, and at best it's a dispute of fact, not no dispute of fact, because Mr. Nelson said he was in canceled status on global shares past March 10th of 2021 all the way to February of 2022.
Is there any evidence in the record that your client attempted to exercise his stock options after March 10th, 2021, before September? Is there any evidence that he tried to do that and couldn't do that?
Thank you,
Through
Your
the
Honor.
cashless option?
Thank you, Your Honor. Yes, you said before September, so I wanted to address Your Honor's question exactly. It was October 27th that the shares went underwater. But yes, in September of 2021, September 3rd and September 9th, my client was emailing with Chadwick Nelson. I have the sites right here. The actual record sites are 380.
And this was the Canada dollar issue, right? Is that when the Canadian dollar issue came up in September?
That came up.
I want to get the site.
Okay, sorry.
Did we get the site?
Yes, thank you, Your Honor. It's 383 and 384 of the record appendix. And that is where they are emailing in early September. I am sorry, I just gave you the wrong site, Your Honor. It's this volume. It is 243 to 244 in the record appendix. That's September 3rd and September 10th of 2011. So there is a discussion with Mr. Nelson at that time, and nowhere does Mr. Nelson say, you can't do anything because you're in canceled status with global shares. So
He doesn't say that?
he does not say that.
How does that help your argument that your client wasn't able to exercise his options then?
It goes to the negligent misrepresentation claim. If he had told my client, global shares is shut down for you, we did something very, very wrong, you got to exercise cash. That is the negligent misrepresentation claim.
But what was
as
the
well.
evidence that your client couldn't exercise his options after March 10th?
It is Mr. Nelson's clear admission on record appendix 385. That's his deposition testimony, and it's cited in our reply brief. It's highlighted very clearly. He says it more than once that Mr. Esler was in canceled status that entire year. And that's what the lower court did not factor into its decision below at all. It was in our opposition brief to summary judgment. It is on page 517 and page 518 of the record, those same record sites.
I think the judge relied on the fact that your client testified, I did not make any effort after March 10th, 2021 to exercise my options. And you're saying, well, there's this other evidence saying he was in canceled status. But if there's no effort to exercise your stock options through the cashless method, how can we know on this record that the judge was wrong to say your client didn't have an opportunity to do that?
Well, Your Honor, I would go back to February 10th and February 11th and late January of 2021, where my client clearly did say, I'm trying to transact. I cannot transact. I was hot to buy, as he says in his deposition. I was hot to buy on February 11th, which...
Sure, certainly up
today is
to March
February-
10th. I mean, there are all sorts of problems that kept him from doing it up to March 10th. The question is after March 10th, then that 6-month period before the stock price went underwater.
Well, Your Honor, I would...
Record on that your client couldn't
Well, I would say Your Honor is correct, that there is nothing before September, early September. However, I would argue that that's a mitigation argument, as we do in our brief. Mr. Esler can be cross-examined at trial. Why didn't you exercise on March 11th, March 12th, March 13th, et cetera? Fine, but that's a mitigation argument. And Mr. Esler has an answer for that, but it's for the jury to decide what the damages should be, in our view.
So we tend to go by the PDF pages because that avoids this. It seems like your PDF pages, the joint appendix pages versus the PDF pages are off by like 60.
60, Your Honor?
Yes, I mean, I'm looking at my PDF page 244 shows joint appendix page 188.
Your Honor, I'll have to check with my assistant. So Joint Appendix 244 should be an email dated September 10th.
So,
And the prior page dated September 3rd. If, I know that we had a pagination problem at the last minute, and my secretary told me yesterday she filed the wrong copy. And so I wanted to bring that up today.
I don't know, the thing that's labeled joint appendix 243 is a deposition page. That's 303 on the PDF.
Your Honor, it may be the fact that the JA numbers in the lower corner are joint appendix on summary judgment.
Okay.
And the upper right corner are record appendix on appeal.
Right, but even when I go to that, you said you were, 244 is addendum to option rollover. Anyway, I suggest you figure that out and proceed as you see fit, but.
Can I ask a quick question?
Yeah.
Just to be clear, your client was always able to exercise the stop options using the Schedule A form provided under the option rollover agreement, correct?
That was a way to do it.
A way
One
to do it. And just, so your complaint is not being able to do it, you couldn't do it through the cashless option, but what exactly was the problem with doing it through the Schedule A form that provided in the agreement?
I think it was just an issue of preference.
He would need to come up with the cash, wouldn't he?
Exactly. Thank you. Thank you, Your Honor.
Good morning, or maybe it's afternoon, I'm not really sure. Members of the panel, may it please the court. My name is Gary Lieberman. I represent defendant appellee. We believe the court should affirm the holdings of the Superior Court on summary judgment. It was a well-reasoned decision, carefully examined the undisputed facts, and properly applied the law. Let me just kind of take a step back and explain. Mr. Esler signed an options agreement. That governed the terms and conditions of the stock options he had with Curaleaf. He had 2.5 years to exercise these options. They were fully vested, and he did have to sign a lockup agreement before he exercised these options. But the lockup agreement specifically says he could only sell a certain number of shares per quarter. And the reason why there's a lockup agreement is the company doesn't want the market flooded. It lowers the value of the stock. Fairly simple. So Mr. Rosen's representation that it benefits Curaleaf to not have a lockup agreement is completely inaccurate.
Well, let's take it back a step here.
All right.
Once they offered the global shares option, does there still a requirement for a lockup agreement?
Correct. There's still a requirement for a lockup agreement. I admit that there were other option holders who did not sign the lockup agreement, but it's clear under the plain and clear terms of Mr. Esler's options agreement, the operative agreement, that he was required to sign one before he exercised his shares, and he did that.
So he says, okay, you offered me this global shares thing, which was of great value to me because I didn't have to come up with $1 million or hundreds of thousands of dollars in cash. I think we could see that's a benefit to him. And then I tried to accept it and benefit you by getting cash into your coffers, but I couldn't.
Okay, so I think the judge properly concluded in this case there's no adequate consideration, and it's certainly not a unilateral contract. He argues that the consideration is the company gets money quicker. Speed. Okay, there's no evidence in the record about that. He wants this court to take judicial notice that there's consideration. This was just merely a convenience for Mr. Esler and the other option holders.
Well, it's a lot more than a convenience. My God, I mean, any idiot would say if I could sell stock and get money without actually putting money in, that's a deal for me.
And
I can sell at 18 and pay 9 after the fact. I mean, anybody would.
But the options agreement he signed, all he had to do was fill out a Schedule A, submit the money, he can get financing. Not that difficult to do that. There are many financing options on record, and all he had to do is send it in. It would take him 30 minutes to do so, and that was the agreement.
Well, let's assume for the moment that the cashless option provided was beneficial both to holders of stock options and to Curaleaf itself, right? Just made this whole transaction easier, avoided all this kind of money moving around that didn't need to. So assuming that there's a benefit to both sides, is that sufficient to establish consideration for a bilateral contract?
I still think it lacks adequate consideration for a bilateral
Why
contract.
is that?
Because once again, there's really no benefit. Like it's basically an employer saying, you know, you can use your 401k administrator's website. It's just an offer to make things easier for the employee, and still does not benefit the company. And I think, Justice Toone, you got it right. By March 2021, he could have exercised his options either by cashless exercise on global shares or signing Schedule A. The record is clear regarding Mr. Nelson's testimony, and I want you to our supplemental index covers that. In October 2021, he didn't try to exercise his options. He reached out to Mr. Nelson with questions that he knew from the day one about this Canadian dollar.
So,
Mr. Nelson.
But was he in fact unable to exercise on global shares because his stock was in canceled status until February 2020?
Absolutely not. In October 2021, he sent a screenshot from global shares to Mr. Nelson. And Mr. Nelson's undisputed testimony was, if his stock was canceled, which it was not, it was only canceled for a short period of time of 8 or 9 days, and that is his testimony under oath. But the screenshot demonstrates that it was not in cancel status. And it's undisputed that
The record site for that?
I'm sorry?
What's the record site for the 8 or 9, that it was
honestly,
undisputed, it was not in canceled status?
I don't have the site with me, but it's certainly in my brief. And in October 2021, Mr. Esler sent a screenshot, and that would prove undoubtedly that it was not in cancel status. Mr. Esler was able to exercise on global shares from March of 2021. Eventually, he was underwater, and that's when he filed his lawsuit. He could have certainly submitted Schedule A at any time during this entire process, and he failed to do so. So he failed to exercise his options. 30 days before the expiration period, he pursued his lawsuit.
How much? Oh, sorry, go ahead.
He argues that it's not true that the lockup agreement or lack of lockup agreement was holding this up. What do you say to that?
That is correct. It wasn't the lack of lockup agreement. There were some errors, and that goes to his alleged false misrepresentation claim. There was nothing false about what Ms. Roseman said to Mr. Esler. Okay, she basically said exactly what's required in his options agreement, that you need to sign a lockup agreement. But there was not, he may have interpreted it that way. There was nothing false about that at all.
But him not signing a lockup, the fact that he had not signed a lockup, there's a lot of negatives in this sentence. He had not signed a lockup, but that was not preventing a sale on global shares.
Correct. The lockup agreement was not the reason why.
So you're representing to us, and that you think the record establishes undisputedly that by March of 2021, he could have exercised his options on global share?
Absolutely. And he admits he never even tried.
Just for the other option, the Schedule A, how much money would he have had to put up in cash to make that happen?
For all the options, something
Yes.
in the range of $2 million, I believe.
$2 million, okay.
And getting to his
I mean, so that makes, I mean, he has a point that the cashless option is much, few of us have $2 million in cash to sort of.
But most people finance that.
Okay, but still, certainly the cashless option was more attractive. You'd see why he'd want to take advantage of that.
Getting to the unilateral contract, this is certainly not a unilateral contract. Classic example of a unilateral contract, someone posts a notice up saying, lost my dog, $250 reward, promise for performance, okay? Here, there's no intent to create an agreement. There's not clear terms at all. It was just a convenience to allow Mr. Esler and other option holders to exercise their options.
But, and you're saying the company just did that out of the kindness of its heart?
You know, when the original option agreement was signed, there was nothing about global shares in it, okay? It found a third party to administer this. Maybe it was less of a headache for them, but it was just a pure gratuitous convenience for option holders.
If their employees or former employees actually did this, it did give the company money it would not otherwise have had, right?
Well, if they never did it, they still could have, and people did submit option A, Schedule A with money still.
You're saying he's wrong when he says nobody used option A.
Nobody in that group, okay?
But
there were other option holders beyond
right.
people who came over from Cura.
What I'm asking is, if an employee couldn't have done A for whatever reason, they couldn't get financing, maybe they were, they just couldn't, and they exercised their option under global shares, that would have benefited the company, correct? Because they would have gotten money, an infusion of cash.
Sure, there would have been a benefit to the company, but there's no evidence in the record that the company earned more money once they started earning global shares. That's just pure speculation.
Was Roseman in January, February 2021 aware of the blackout situation, the wrong termination date, and the wrong expiration date?
When Mr. Esler raised concerns about global shares, she looked into it, and she attempted to fix it. He was subject to a blackout. They fixed that, then there was a wrong termination date, but eventually he was able to exercise those shares once he signed the lockup agreement and never did.
When did he sign the lockup agreement?
I believe March 2021, I don't know the exact date.
So I guess I just, sometimes we actually just try to understand what happened and
Sure.
understand what is just, like, is this just the unluckiest guy in the world? Like, what went wrong here? Because it seems like
Well,
you could
I
fix
think he
problems
was-
for other people, but not this guy.
I think he was a little bit unlucky, but also he lost a lot of money by not exercising his options. He could have exercised his options many times. Nothing precluded him from signing Schedule A. As of March 2021, he could have exercised his options, and I think there's a footnote in our brief, he would have made $400,000. Okay, but there were some errors on global shares that Curaleaf failed to inform them of, but those were fixed rather quickly. And after they were fixed, he still didn't exercise his options.
Well, there I get that, to the extent you fix the errors, like, and he could have exercised in March, I could see why you might be liable for the highest point to the March 10th point, but not anything after that. But, I mean, he's arguing that a jury should decide that whether his reliance on your statements about global share was reasonable. Why is he wrong about that?
He's wrong about it because there's no false statements. He's claiming that Mr. Roseman said, "I'll fix it," okay, was somehow false, okay? It's a future promise. And case law is clear that you can't make a false representation about a future promise. And there's no evidence of detrimental reliance on that, okay? He didn't put out any money, and he's only entitled to detrimental reliance on that claim. He's not entitled to benefit of the bargain. And that was one other thing the judge decided about on this case. So he didn't lose anything. And on a false misrepresentation claim, he would be entitled to.
Why didn't he lose an opportunity?
But that's not, on a false representation claim, the case law is pretty clear that you're only entitled to pecuniary loss, not opportunity loss. And there's cases cited by the judge, cases cited in our brief that clearly cover that. Regarding his fiduciary duty claim, he's trying to, compare it to ERISA. There's no evidence that Curaleaf would have a fiduciary duty by offering this, third-party administrator for option holders to exercise their options. His negligence claim, the economic loss doctrine makes it clear that he cannot recover in negligence unless there's a physical injury or property damage. That claim should be dismissed. And based on the summary judgment record here, the evidence in this case, none of his claims should survive.
Thank you very much.
Thank you.
Well, I don't know that I'm going to say we understand, but we've made your arguments. We have your papers. And the case is submitted. The next case is 2024 P227, FLOESSER versus Belmont Instrument Corp. We'll hear first for the attorneys for Belmont Instrument Corp.
Good afternoon, Your Honors, and may it please the Court. Emily Musgrave on behalf of appellants, and with me is my colleague, Sav Arguello. There are two prejudicial errors at issue in this appeal. First, the trial court allowed an 11th hour witness, Karen Clark, to testify even though plaintiff never included her on a single pretrial witness list. Defendants strenuously and repeatedly objected. If the rules of pretrial disclosure mean anything, it's that witnesses have to be timely disclosed to avoid unfair prejudice at trial.
So you acknowledge in your brief that the plaintiff disclosed in interrogatory responses that Clark was a person with relevant knowledge, right?
Actually, no, Your Honor. So the plaintiff's interrogatory responses were not included in the record, but I have seen them, and the interrogatory at issue requested the list of names of people at Belmont that plaintiff had communicated with. So it's not even one of the sort of standard people with discoverable knowledge, but even if it were, it doesn't change the outcome. There is a vast difference between names disclosed in interrogatory responses at the start of a case, which can be quite a large universe, and when that universe is winnowed down to the witnesses who a party actually anticipates calling at trial.
So I thought, I mean, perhaps I'm misreading your brief. I thought on 33 that you indicated that he had disclosed witnesses that had relevant knowledge, and that included Clark.
Yes, Your Honor, the phrasing may have been inartful. I think that the point is even if he had, it wouldn't change the outcome. But when we went back to look at it, because again, it wasn't in the record appendix, the interrogatory doesn't quite say that. But again, I think the point remains, which is that even if it did, it really doesn't change the question here, which was about the names of witnesses that were included on a joint pretrial witness list, and then on the parties' respective witness lists. And those witness lists mean something. That tells the parties.
Is it correct? Yes, it's true, but sometimes these things happen. So is it correct you never asked, your client never asked to depose Clark?
That's correct, Your Honor, and I think the timeline here is relevant on that. Clark was first injected as a potential witness at trial in defendant's reply in support of his motion to strike one of plaintiff's motion to strike one of defendant's witnesses who had been.
He's saying you didn't really disclose forward, and so it was really your late disclosure that's prompting his late disclosure.
That's right, Your Honor, but Forward was on the joint pretrial list, which was prepared a full year before this motion to strike. So Forward's name had been on that list for a year at the time when Clark's name was first mentioned. And when Clark's name was first mentioned, it was again in a bullet point as an alternative basis for relief in support of a motion to strike a witness. The witness list was never amended, and but to get back to Your Honor's point, Clark was indeed never deposed.
So I take it that FLOESSER's testimony was he did a great job and that you could easily find the documents that your client said weren't easy to find, right?
I think that's a fair summary.
And counsel for the defendants was ready to and did cross-examine him vigorously on those points?
Yes, Your Honor.
And then Forward said, no, this was not industry standard, this was very disorganized. That was his testimony, right?
Yes.
Okay. And the damage for you for Clark was that she no longer worked for the company, right?
I think the damage was that.
No, she no longer worked for the company, right?
Right.
So the damage for you was now you have this independent third party who really doesn't have a dog in the hunt, was like, yeah, the stuff was fine, we could find everything.
I think that's part of the damage, yes.
What was there more?
Well, the other part was what she sought to testify to was that she sought to compare the systems at Belmont.
She didn't get to succeed in that, right?
Correct, Your Honor. And I want to come back to the court's question about depositions, which we make this point in a footnote in our brief. It's sort of a heads I win, tails you lose argument, because if the standard is that a failure to include a witness on a list imposes on the other party the burden of twisting themselves into a pretzel in the 11th hour to depose the witness, they're placed in a really difficult spot. If they don't move to depose the witness, then they get criticized for not having done so. If they do depose the witness, then it becomes very difficult for them to argue the prejudice.
Why can't they argue both? We really object to this, you should hold the standards, blah, 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 but, let us depose the witness.
They could, Your Honor. But the fact is that the witness here was not deposed. And given the late disclosure, it made it very difficult to do so.
That's the part I don't quite understand. Your whole case was that these records were disorganized, and you had to have had some evidence to prove that. So if you could be in the position to vigorously cross-examine the plaintiff, why couldn't you then cross-examine Clark?
I think for a couple reasons. First, there was some testimony that Clark gave, particularly about the way in which the systems spoke to each other, that I do think was distinct, and had there been a deposition, there would have been an opportunity to explore that. As trial counsel, we learn, I think, at first principles, not to ask a question in cross-examination that we don't know the answer to, and here trial counsel couldn't have known those answers.
That's generally a good idea, but really good trial counsel can, in fact, impeach a witness without, they don't always need actual evidence, and it's a thing of beauty when it happens.
I understand, Your Honor. Here, though, the only reason that trial counsel was not provided the opportunity to take this deposition in ordinary course was because this witness wasn't disclosed properly on any of the witness lists. The witness lists were never supplemented, they were never amended, her name wasn't on them. And so throughout trial, every time her name does come up, and I would submit that happened actually quite rarely, there's a full colloquy and objection that happens on the record with defense counsel saying this is not appropriate.
I'd like to turn to your second argument about the closing argument and the instructions. If the jury had found a breach of fiduciary duty for bad faith failure to pay, wouldn't the damages amounts of the two claims have lined up exactly?
Your Honor, I don't know what the basis is for that $170,000 award on the breach of fiduciary claim, which I think is where Your Honor is going.
Yes.
I'm not aware of any basis in the record for it, and my brother doesn't mention any in his brief. I think the key on that particular issue is that the jury told us what they did, and I'd submit that's relatively rare. We spend a lot of time parsing what the jury must have known or must have thought or what questions they would have had, but here they actually sent out a question and told us exactly what they were struggling with, and then that question that they asked maps perfectly onto the verdict form, where they then are presented essentially with two bases for this breach of fiduciary duty, and they find one and not the...
awarded the same amount of damages.
I'm sorry, Your Honor?
Why wouldn't they have awarded the same amount of damages?
I don't know the answer to that, Your Honor, but I'm stuck on their note and the way it maps onto the verdict form, which suggests to me that they were very clearly asking the question. I mean, they asked, and this is at Record Appendix 2, 2358, does a fiduciary duty relate to the medical disclosure, or does it relate to not paying out the plaintiff helmet for the stock proceeds? And then if you look at the verdict form...
Right, but that leaves room for bad faith failure to pay him.
It could, except that they were never instructed on that. They were never instructed that a bad faith failure to pay, assuming that is the law as we derive it from Chokol and from the Demoulas case that we cite, the jury were never instructed that a bad faith failure to pay could perhaps be a different basis on which to find liability, even in a circumstance where the acts are covered by a contract. They didn't know that.
After the question came in from the jurors, I know that you object to the judge not giving only a general instruction, remedial instruction, in response to the argument by counsel. But the second time around, she says anything that the lawyer said relative to any of the claims legally is to be ignored by you. And that's pretty direct about addressing, don't take into consideration the arguments of counsel, focus on the facts, right? Was that still deficient in your view in terms of a response?
Insufficient in the circumstances, Your Honor. And in fact, what the colloquy that happens on the record before the judge gives that second curative instruction, this is after the jury has asked their question, what that colloquy demonstrates is in fact both parties were proposing much more specific language that the judge could have given to remedy that particular legal error. And the judge sort of defaults to this more...
Flosser's counsel, right, said let's give the instruction failure to pay a loan is not a breach of fiduciary duty. You've got to find additional conduct or bad faith. And you all objected that instruction on the grounds that, well, that's already in the Honor's instructions, right? So they were trying to get really to the heart of the matter and clarify this, and you said, no, that's not what we want. So I don't know, it seems a little unfair to now say, well, the judge only provided a general instruction when she avoided this. You all said no at the opportunity to kind of really get to the heart of the matter.
I think we wanted something more specific than that, Your Honor. I mean, at that point, what the jury needed to be told was a direct response to this question, because I think the question was actually pretty clear and pretty pointed, which is, does a failure to pay provide a basis for a breach of fiduciary duty? And the instruction ought to have been that as a matter of law, it does not. And that's what defense counsel was advocating for. And so I think Your Honor's description of the judge's curative instruction is it was fairly generic.
So what page are you referring to when you say that?
When I say, I'm sorry, what part, Your Honor?
That there was a proposal from the plaintiff's attorney, and your client rejected that. So that's where I'm asking where that is. He's on 2351. Okay.
Absolutely, Your Honor, and I will find the record site for you. So this colloquy begins at Record Appendix 22344.
Yeah, but on 2350,
yep,
the plaintiff says, actually he says it on 51. He says, if your instruction is a failure to pay a loan is not a breach of fiduciary duty, however, if you find additional conduct or bad faith in the failure to pay, that may be a breach of additional duty. We have no objection. And you say that's already in your client's attorney says that's already in your Honor's instructions. Now it seems like you're saying it wasn't in the instructions. So
That's right, Your Honor. I don't think it was in the instructions, and
Well,
what
right,
appears
but
to
then
be...
then it's not a preserved error, right, with the jury instructions?
I think it is preserved given the way the colloquy continues after that. And if you look at the end of that page of 2351...
We can't flip a trial because your guy got the exact, it was offered the exact instruction you now want, and the lawyer said no.
It's not the exact instruction that we wanted, respectfully, because that instruction went on, there's a semicolon there at line 3, and it went on to say, however, if you find additional conduct or bad faith in the failure to pay, that may be a breach of fiduciary duty. That was a new concept that had not previously been included in the jury instructions. I don't think that would have been a fulsome instruction on what a bad faith failure to pay would have looked like, but what I think defense counsel was saying in that moment is if you go to the end of the page, it's always difficult to do this from a written record that's not oral, but clearly this was a relatively heated exchange because at the end of the page, the court says, and this is line 21, well, you all can step back because I have a list if you're going to behave like that, which when we hear that kind of language from a trial judge suggests to me, reading it after the fact, that this may have been a pretty heat of the moment colloquy. And the colloquy does continue extensively with various instructions being proposed, I think any one of which, although of course I would advocate for the one defense counsel offered, would have been better than you take the law from me and not from the lawyers, which in this circumstance wasn't enough. And I come back again to the fact that we have a note from the jury telling us exactly where they were confused, and that maps directly onto the verdict form, which again is a relatively rare circumstance. We don't have to guess at what they were thinking, they told us.
That seems like a very strong reading of the jury's question. If the jury's question was just, can breach of fiduciary duty be only his health, or can it relate to failure to pay, and they could have left out in bad faith, then where does that leave your argument, if that's a possibility?
I'm sorry, I don't understand Your Honor's question.
The jury is saying, if they're saying, well, could breach of fiduciary duty, is that limited to Mr. Herslinger's health, or could it relate to not paying? And they don't put in, but they mean in bad faith. Then how does that help you?
Well, again, Your Honor, I don't see how they could have not put in but meant in bad faith, because they didn't know that. Nobody had explained to them that there was this concept of in bad faith. It wasn't argued to them in summation. They weren't instructed on it.
Well,
so I don't read that
in the very paragraph of the closing that you're complaining about, he says, we showed this breach of the covenant of good faith and fair dealing to make up excuses for cause when you never terminated him for cause. I mean, there's a context here that...
I agree, Your Honor, but that is a bad faith discussion in the context of the implied covenant of good faith and fair dealing, which was a separate point on the verdict form. That was count 2, and it's incorporated in question 1 on the verdict.
But isn't this the paragraph with the language you're complaining about? Because this is the paragraph where they say, and of course this is being transcribed, so we take the court reporter's transcription, but I don't know where, they put in semicolons. I mean, that's up to the transcriber. But it says, what you're complaining about is the sentence on 2314 at line 12 and 13, which was they owed Mr. FLOESSER a fiduciary duty. It was breached when they failed to pay, right? Yes. That's what you're complaining about.
Yes, Your Honor.
Right, and they're saying that in this context, it was because they were making up excuses for cause.
That the failure to pay.
Yeah. But you're saying, okay, the context of this was the breach of covenant of good faith and fair dealing, but then you're saying, no, but the context is breach of fiduciary duty.
Right, I think they're two different legal theories, but the problem is that, I think, Your Honor, I draw something different from the same set of facts. The issue of the failure to pay is what had dominated the trial. That was clearly front and center in all of the trial and all of the testimony, and that's what was ringing in the jury's ears. And then there is this statement that is, if you find that they failed to pay, you can find a breach of fiduciary duty. And they were never instructed otherwise, though they could have been.
Where is that? Which page is that on?
I'm reading the same line. It was breached when they failed to pay.
Okay, because that's a little different than what you just said, which is much stronger for you.
Yes, Your Honor. It says it was breached when they failed to pay.
Thank you very much. We'll hear from counsel for Mr. FLOESSER.
Thank you.
Good afternoon, And may it please the court, my name is John Ray of Ray and Counsel, and I represent the plaintiff appellee HELMUT FLOESSER. I was also trial counsel, so I was there throughout the 3 weeks in Salem after Halloween. We started November 1st. It was an interesting ride up and down the elevator the evening before as I was printing out exhibits. But I want to get to this because the jury in this case heard 10 days of testimony from Belmont employees, all of whom testified substantially on behalf of plaintiff. No Belmont employees showed up to testify on behalf of the defendants. The only one who did, pardon me, was Jeff Forward, a subsequent employee who actually was only at Belmont after the merger and 2 years after FLOESSER had resigned and left. So when Mr. Forward is talking about what systems and documentation there were at Belmont, what he's talking about is a 2-year gap between when he arrived and when FLOESSER had left. He was the only person
Right,
who had...
but if that was so devastating, then you didn't really need to call Clark and risk your whole, inject a possible appellate argument into this.
No, I think that it was important. This was a person who said, none of these documents were there. None of these systems were there.
Forward was saying.
Forward was saying this. We only learned of Jeff Forward and what he would say weeks before the trial. He was
listed. He says you learned of him like 14 months before the trial, right?
His name was listed, nothing else. We asked in interrogatories to identify individuals with knowledge.
I mean, part of the problem here is she's saying there's no interrogatories in this record, and in fact, you say repeatedly in your brief, you had disclosed Clark's name 5 years before trial, but you never cite to anything to prove that, and we don't do that here.
What we did was, we cited to what we had cited in the brief to the court, where we cited, I believe was...
I didn't see a cite, and I made my clerk look for
the sites in the brief.
Where's the site? What's the site?
I'd have to look back, but we did raise this issue in the brief.
I want to be clear right now, because we looked, and I'm not...
I don't have the record with me.
Right, but I'm telling you, we don't have a site for that. That means it does not exist unless there's a site for it.
We raised the point, they've never disputed it. They've never suggested this was not, in fact, they've admitted to you that they know that she was.
Well, she's trying to, she admitted something in her brief, whatever she admitted, she's now trying to take it back.
It's
we
changed.
We also don't do here either, but.
It's changed. All we're saying is, as to Jeff Forward, he never was. We got the name. What they're relying on is not a disclosure of what he would testify to, a disclosure of simply his name. They're suggesting because we didn't give the name, that somehow we were, when we learned of what he was going to testify to, our understanding was simply corporate transition and succession issues, which was an issue at trial, was disputed in the record at trial, until the parties came to a stipulation as to corporate succession, which was our understanding of Jeff Forward. It was only weeks before the trial that we knew, for the first time, because there was no supplementation as to what he knew, he's going to talk about something else.
So you had no idea before trial that the defense was going to focus on your client's performance at Belmont as an issue in the case?
No, we had no idea they were going to suggest there were missing documentation.
Okay, but you knew that your client's performance was going to be an issue, right?
Right, we knew that.
So calling Ms. Clark to sort of rebut criticisms of your client's performance, I'm not sure... that has to be something you knew in advance to be helpful to have her testimony. So why didn't you disclose her far earlier than you did?
No, because we weren't going to talk about that issue. In fact, quite frankly, we said if you're not having Jeff Forward, she's not part of our case. We want to be clear. There was a plaintiff and a counterclaim plaintiff. They were counterclaim plaintiffs. This was not part of our affirmative case. We said we aren't mentioning any of these issues. We're not putting them forward. What this was not even a rebuttal necessarily, but for the first time we're learning of what their case really is. We're presenting the response. We weren't going to say, If they had general criticisms, we deposed Regina Herzlinger I deposed Regina Herzlinger extensively. There was no discussion of missing documentation. We never knew. We knew there were general criticisms, some specific criticisms. We prepared to address everything we knew of. Then we learned they were going to for the first time, talk about missing documents, which is why you didn't see trial exhibits 61, 62, 3, and 4, and 5 until the end, when we said, now you've suggested that even Clark is lying about what she saw. Now we'll bring forward yet again those exhibits, 61 through 65, that show those specific documents. That's the issue we were dealing with. And I want
You're
to...
saying you put out Clark's name 5 years earlier, and then they put out Forward's name a year or 14 months earlier, and then you were squawking and you asked for the deposition of Forward, correct?
I did.
And you asked that to be able to call Clark. You had paragraph 3 in your reply brief said, and we want to call Clark.
Yes.
Okay.
We were a two-person firm.
No, that's fine.
Quinn
And
Emanuel, I'm sorry.
This might not be relevant, but you have a sentence in your brief that I just didn't understand, which is on page 34 of your brief. On the last line, it says something along the lines of Regina Herzlinger and Roger Fastnack's to control of those systems after FLOESSER. And I don't know what to control, I'm like, is that two-factor authentication? Is that like?
I'm on page
34, last line.
Last line.
Referencing to control.
Okay. Was forced to admit on cross-examination to his limited knowledge, Regina Herzlinger and Roger Fastnack's to control.
Yeah, that's what I don't know what that means.
2-year control.
2 year, okay.
Of those, I apologize.
That's okay.
That confused me too.
Yes.
But at the end of the day,
Okay.
we did cite the extensive case law with respect to the issues that delay itself is not sufficient. We cited cases specifically on page 32, a couple pages before, including Commonwealth versus Dranka, Commonwealth versus St. Germain, where in both cases, Dranka, there were 2.5 days.
I think we have a handle on that argument. I'd like to turn to the closing argument issue. If you do look at page 2314, you start somebody starts the paragraph about the breach of covenant and good faith and fair dealing, but then changes directions and says they owed, meaning Herzlinger and the officers at Belmont, they owed FLOESSER a fiduciary duty, period. It was breached when they failed to pay. And then there's more, but
Right,
it looks like a naked statement that mere failure to pay is a breach of the fiduciary duty.
What we said in the paragraph preceding was, as I'm concluding, and I'm talking about some of the claims, at the beginning of the case, we promised that we would demonstrate facts to establish all the claims that we've identified. What we were talking about was going over all of the facts that related to all of the claims. And it was a progressive argument as to each, that we've established that there were false and unsupported allegations, and that this was a breach of the covenant of good faith to make up excuses. It also was a breach of their fiduciary duty.
Well, so let me just pause you. Is mere failure to pay under the agreement on the stock options by itself, no bad faith, just failure to pay, is that a breach of fiduciary duty under clearly established law?
No.
Okay.
And that is why we didn't say it's a breach of the fiduciary duty. We said it was breached when. And I think the when is important. We were talking about the circumstances. We had just detailed all of the circumstances, all of the facts that apply to all of the claims, and said when they did this, when meaning all of these things, that's when they breached the fiduciary duty. The jury understood it because they came back with a verdict that was dramatically different as to both counts. Now, my sister counsel places a lot of emphasis on the question that was asked. And if we look at the verdict form, there's actually a very simple reason why they asked the question. They were asked, and this is on, it's in our brief at page 60. We obviously included the jury verdict form. This is at the record appendix 329. For breach of fiduciary duty, at the top of the page, it's underlined. The first question is, did Regina Herzlinger breach a fiduciary duty owed to Mr. Flosser? It doesn't identify what the basis is. Second question, did George Herzlinger breach a fiduciary duty owed to Mr. Flosser? It doesn't say what the basis is. If you answer yes, question 6, what amount of money, if any, will fairly compensate Mr. Flosser for his damages? Determination. Then there's a special question that confuses the jury. We've already made our determinations on 4, 5, and 6, breach of fiduciary duty, and then there's question 7. If you found Mr. Flosser was entitled to payment of damages on his breach of fiduciary duty claim, how much of those damages, if any, were caused by George Herzlinger's health issues? Wait a minute. We didn't even know that was an issue. Let's ask a question. What does the breach of fiduciary duty claim involve? Does it relate to the stock options, or does it relate to the health issues? We just put a verdict together on the stock options and the bad faith, and now we're being asked in a special question about the health issues. That doesn't exactly make sense, which is why that's the question. What was really covered then, Your Honor, by questions 4 and 5?
So do you have any idea where they came up with $170,000?
Why they specifically did it? No, I don't. I mean,
Offer a value of damages on breach of
we
fiduciary
didn't offer
duty?
specific numbers. What we said and what we argued was simply that, based upon the instructions that the court would give, you could make determinations about the economic impact and damages that this caused Mr. Flosser. Now, we can speculate as to what economic damages and the determinations they made, whether injury with respect to his earnings capacity, for instance, in it going forward, whether they thought there was some specific economic damage as a result of the amount of the effort and time in terms of addressing these issues and repairing his reputation. I mean, I could go on endlessly in terms of...
I don't understand, though. Didn't he leave and he had another job, right?
No, he didn't.
Oh, he did not. He just left.
Yes. And then they started launching accusations at him. So what he did was he just opened up a business for himself. And I think he testified about that. The jury, I can go on and speculate what
He
the...
testify as to it took a certain amount of time to get back up. What was is there evidence of what his last salary was at the company?
And that's a very good question. I did not look it up in terms of what his last year's salary was, but I think it was in this range, which also may have represented where the jury got the number from. The time that he had lost with respect to trying to repair his reputation and the damage done, a 1-year reasonable amount, or whatever their determination was. The issue was for them.
So in looking at the jury instructions, and again, I'm looking for a record site. Apparently, we're going to put that under my name in the appeals court website. Maybe I'll go ask for that as soon as we get off the bench. Where in the jury instructions does the judge say that failure to pay in good faith is not a breach of fiduciary duty, or conversely, that the failure to pay has to be in bad faith to be a breach of the fiduciary duty?
I don't believe she posed it in those terms, and I can certainly look for the record site.
I know he said, the attorney for the defendant said it was already in there, but I'd like to actually see it in the jury instructions.
It's not in the way that we proposed it. I know Harvey jumped up and said it, and it obviously interjected a lot of problems. He did that a few times that made this difficult, but, and I know, and like Harvey, I've worked with him. He was a colleague of mine at Ropes, so I know him well. But he did jump up a lot to do that. It wasn't specifically in those terms. It was simply that it had to be good faith, that good faith actions were consistent with their fiduciary duties. So we argued that they had not acted in good faith. But there wasn't a specific instruction that broke down that issue, because quite frankly, during the course of the hour that I argued, and quite frankly, during the 10 hours of trial witnesses and cross-examination, no one thought, as I went and cross-examined Regina Herzlinger for false statements, Jeff Forward for false statements, and their expert who they put forward claiming some $45 million of damages, and I cross-examined him and they got 0. No one thought the allegations that they put forward and the claims that they made, over which they were thoroughly cross-examined and discredited, were anywhere close to good faith, which is why this verdict came back this way.
Right, your time is up, so I just want to make
Thank
sure
you.
there's no further questions. Okay, I think we understand your positions, and the case was definitely well argued, so we will take it under submission, and we will hear our final case of the day, which is 2024 P384 DC versus PN. This case is partially impounded, so we're not going to mention names here.
Sorry, Your Honor, I didn't quite catch that. You refer to the parties as appellant and appellee,
Or, I do apologize, they were married at one point, right? We could just refer to them as either mother and father or husband and, or
Mother and
ex-husband
father is fine. They were not
okay.
married.
They were not married. Okay, so mother and father seems like a safe way to proceed.
Certainly. Good afternoon. May it please the court, I am Jennifer Lamanna and I represent the appellant mother in this matter. We're here before you on an appeal of the vacation of a 209A order that we submit to you as a clear matter of law should have been extended. The court improperly focused its attention on the passage of time since the strangulation and assault and battery, which is undisputed, of the mother by the father, and spent an inordinate amount of time also debating the status of the probate and family court proceedings. I would submit to you this case is almost exactly like Latoya L., with the exception that in Latoya L., the appeals court found that there was insufficient evidence in the record to show that the court based its decision upon what was happening in the probate court proceedings, and I would respectfully suggest that is not the case here. There is an extensive amount of debate in these proceedings, not about the mother's continued fear after a serious physical attack, not about her sense of isolation, not about her lack of peace, not about her need to feel secure and have the order in place, but rather about what the proceedings were in the probate and family court. Whether or not the court at one point indicated, how long does this have to go on? These aren't supposed to go on forever unnecessarily. And of course, as recently as yesterday, another panel of the appeals court said, that's not the case. That's not the case. Restraining orders can certainly continue permanent and be permanent. They can go on forever if that's what is necessary. And so I'm certainly not suggesting that at an extension hearing, time is not a question before the court, but the amount of time that should be taken into account should be the time necessary for a plaintiff who is undisputably a victim of strangulation and assault and battery, the amount of time that that plaintiff needs in order to feel secure. And that was not the inquiry that was conducted here. In fact, although there's a lot of blame to go around, I think, as to why there was so much debate about what was happening in the probate and family court proceedings, it was certainly brought up by Mother's Counsel. I believe he led his argument with, let me give you some background, and then wanted to talk about what happened in the probate and family court proceedings. It appeared from the transcript that he was doing that because he felt that that was a necessary part of the inquiry. But he did eventually segue pretty strongly, I think, into why she's in fear. The father's criminal background, the specific actions that took place here.
He says the Rhode Island thing was a fight between men and 20 years old.
Yes. There wasn't significant evidence in the record as to whether that was an accurate portrayal, whether it was 20 years old or not. I don't think my clients, I don't think the mother's fear of after having been strangled and assaulted by this man was dependent on whether he'd ever done something to anyone else. And one of the most troubling aspects of the hearing that took place here was, I think, Father's counsel's suggestion that he's over this. He's moved on, and all the animosity, he says to the court, is coming one way now. That it's the mother feels animosity, and he asserted to the court, we have a GAL report, which she then said, can I see? And he, very improperly, passed it forward over multiple objections by mother's counsel about its irrelevance and its age. He didn't bring up specifically the fact that he's not even allowed to produce it in any other forum other than the probate court. But nevertheless, the court looked at it, and there was significant discussion about what this unsworn witness's opinion was in a document that's not in evidence in either the probate and family court or the district court. And the suggestion was actually made that at this point, he wants nothing more to do with her. He's over it. He's not drinking anymore. He's fine. But the question was not, the question before the court was never whether or not the defendant was likely to do it again because of the seriousness of the original attack. The question was whether or not she, the mother, still felt the need for that order. And by flipping it on its head and turning it into she's the one who has animosity now, she's the one continuing the anger, that it was demeaning to her and it was improper. Because as the court very clearly stated in Latoya L., where there was a significant physical attack that was the basis for the original restraining order, the reasonableness of her fear, the reasonable basis for her thinking she was at imminent risk of another attack was not the question before the court, but rather the question was, does she require the continued protection of this order? Her attorney eventually asserted that indeed she did. He pointed out her isolation, the fact that she has no family here. He pointed out the fact that they live near each other.
And counsel, his pointing out that really isn't evidence.
Pardon me?
The burden is on the plaintiff, correct? And attorney's argument are not evidence. At what point was there an obligation on counsel to say, I'd like to present evidence, I'd like to have the mother testify?
Well, as Your Honor's aware, restraining order hearings, there is broad discretion as to how they are conducted. The court is not required to allow cross-examination or extensive cross-examination.
But there should be some evidence presented, correct?
There certainly should be some evidence.
And there was no evidence presented in this entire hearing, was there?
I disagree with that. And I think, while I certainly agree with you that the traditional form of evidence, which is testimony or documents, had not been resubmitted, but of course the court had as part of its record the original affidavit and the second affidavit filed by the plaintiff. Those were evidence, and the assertion was certainly made on the record that the fear created and fully described in those two affidavits continued to exist.
Those assertions are made through counsel, right?
They were made through counsel.
It does seem to be a problem or an issue that, the father's main argument now is you didn't put on evidence at the extension hearing, but rather made representations through counsel about mother's continued fear of father. And I guess, is that enough? Do you have to make some kind of evidentiary showing, or did counsel at the time anticipate that the judge would be asking questions? It just sort of, I totally take your point about continued fear. A prior violent incident can be enough to establish the basis for that, but do you need some evidentiary hook to actually have there is continued fear, not just through argument by counsel?
I think that really hinges on the discretion that the district court or probate court judge hearing the 209A order has regarding the conduct of the hearing. These hearings very often proceed solely on arguments of counsel. But I will also note that the plaintiff, the mother, at the end, said to the court, may I speak? May I? And the court said, no, we're done. So if the court was ruling against her on the basis that she had not spoken herself, that was the time for the court to say so. And there was certainly no objection by the defendant, and at no point did father's counsel ask to be allowed to cross-examine the mother as to the basis of her fear. And of course, as I'm sure you noted, father's counsel himself proceeded and made a number of representations on the record, factual representations that were not supported by documentary evidence, brought in references to other proceedings, what judges thought in other proceedings, whether judges were angry or not, none of which was germane to the issue before the court, which was whether or not this particular plaintiff was in fear. I'm not expecting to walk away from this hearing with broad new parameters for how restraining order hearings should be handled, because district court judges and probate court judges are given broad discretion. Many of these people are pro se, and I certainly understand the need for that. I've certainly handled hundreds of restraining order cases myself and very often been told no when I wanted to present testimonial evidence. And very often, judges rely on the affidavits and the presentation before them. The problem here is that it appears from the transcript that the hearing began from the premise of, this has gone on long enough. How much longer does this need to be in place? And there's even some discussion at some point, I believe it's on page 36 of the transcript, where the judge actually directs her attention to father's counsel and says, this could actually make it more difficult for your client in terms of communication, et cetera, because of the ongoing probate matters. Again, completely unnecessary and irrelevant. The consequences to the father of his conduct, how that's affecting his visitation, was not the inquiry before the court. And I will note further that when, again, mother's counsel was asserting her fear, father's counsel's response was, he wouldn't do that again. This could affect the custody of his children. Well, that didn't stop him the first time. And the suggestion that his current state of mind was what was controlling, whether or not he would do it again, whether he wanted anything to do with her, whether custody of his children is enough to stop him from trying to strangle her again, was never the inquiry before the court. But her need for the security, her need for the protection. And she's now been without that for over a year. And I would love to be able to argue to this court to simply reinstate the order. I think a remand is what is necessary for a fuller hearing. And if the determination, there's certainly no evidence and no reflection from the judge's ruling that the reason she ruled against the mother was because she hadn't heard enough about fear. But it does appear it was based on the amount of time that had passed, the judge's presumptive belief that these aren't supposed to go on forever, and this very detailed and confusing discussion about what was going to happen in the probate court and how this 209A order would affect those proceedings, which I respectfully suggest all of which was improper. I have some time left, but I don't want to keep going over the same point.
If you feel like you've covered all your points, then there's no need to repeat them.
Thank you.
Good afternoon, Your Honors. Edward Gaynor, I represent the father. We would respectfully ask the court to refuse to disturb the holding of the district court, which refused to extend the restraining order in January of 2024. Initially, I'd just like to note that by the preponderance of the evidence, it's incumbent upon the complaining party to show that.
Right, but she's saying that she wasn't even permitted to. The judge just started out of the gate with the wrong standard and carried that all the way through the hearing. And then, mother then even says at the end, "May I speak?" And the judge says no.
Well, I mean, that's not really what the judge did. I think if in a fair reading of the transcript, the judge did indicate that the case had been going on for quite a while and invited the parties to show her why the restraining order should be continued. And that, I mean, that was really the second time that it would have been appropriate for the mother's attorney to start, examining his client. The first time would have been at the beginning of the case. The fact of the matter is that he really, I wouldn't say refused, but declined to do so. And there's no...
I wanted to give background. I think his point was there was a short date because the parties had agreed to align the date with procedures in the probate court. That seemed like his initial purpose, and then it seemed to go sideways from there.
Well, that was one of the initial reasons, I believe, that it had been continued from October 6th to the January 24th, I believe it was, date. There were actually 3 different hearings before that time. There was one in March, There was an ex parte one in March. There was a second contested hearing at the end of March, and then there was a hearing in October. But each time these hearings were continued incrementally. They weren't continued for a year at a time. So presumably whoever the judge was that was hearing them felt that there was no need to issue a blanket order.
Well, let's not presume. Counsel, let's focus on the transcript. And I'd like to reference at 80 Mass App Court 423, there's a matter of, one moment. It's ST versus EM. In that decision, the court noted that these hearings aren't like trials, but there is a minimum due process requirement, a fairness requirement. And the second fairness requirement, this court, I think it was Justice Hanlon, mentions or lists is judges should not issue or vacate any part of an abuse prevention order over objection without hearing the evidence and giving the parties an opportunity to respond. When during this hearing did the judge hear the evidence in this matter?
There was none offered.
Well, the plaintiff was sworn in. That was for a purpose, right? She stood up and rose her hand and took an oath, correct?
She did.
Doesn't that indicate to the court that she's going to be a witness at the hearing?
Her attorney didn't call her.
Well, during this background conversation, the judge just interjected, so I agree with you, counsel, father's counsel, that it's likely this should be terminated. And they hadn't even really gotten into the evidence. They got into no evidence.
I was at the very end of the...
It wasn't at the very end, counsel. It was on page 21. The court says, so counsel for Mr. Nolte, Mr. N, I tend to agree with you that it makes sense to terminate the restraining order. And the only thing they discussed up to that point is the parallel issues in the probate court.
I don't think that the judge in the district court is responsible for the conduct of the hearing in the sense that they are supposed to be deciding who to call and what to present. That is really the crux of this problem. She was represented by counsel. He didn't call her to the stand. He didn't introduce any evidence. He didn't introduce any exhibits. And
well, counsel, when the judge said it's terminated, the hearing was summarily concluded by the clerk and the court officer.
It was.
The plaintiff said, Judge, may I speak? The attorney tried to address the court, and the hearing was over. So what opportunity did they have to present evidence?
They had a full 20 minutes to present evidence, and at the end of, I think the confusion is that they decided to put on a presentation as opposed to actually submitting evidence. And the presentation is not evidence. The representations of counsel are not evidence. And what happened at the end of it was after the judge had rendered their decision, they weren't liking what they were hearing, and the plaintiff, the mother at that point decided, oh, I want to speak. The hearing's already been concluded.
The judge had stated by that point that restraining orders are, quote, supposed to be limited and not supposed to go on forever unnecessarily. But that's not really correct, right? Our judges have discretion under 209A to grant permanent abuse prevention orders, right? And so that was just kind of a misstatement that maybe have, led to the cutting off of the plaintiff's case at the end.
I'm not sure that it actually, the statement itself is indicative of the judge's frame of mind. I think the judge is, in some sense, in some senses correct. I mean, the restraining orders are only supposed to go on until they're only supposed to go on until they're no longer necessary. And it was a sloppy way to put it, and I'm not criticizing, well, I guess I am by using that pejorative word, but it's not an inaccurate statement in and of itself.
Well, given that judges have authority to issue permanent orders, right? That necessarily implies that they don't. Not all orders need to come to an end, right? Not all orders are supposed to be limited. In some cases, judge orders should be permanent. And so it seems like the judge here didn't really come to terms with that point. And
I think I don't think that one can say that, and the reason that I don't think that one can say that, and it may be a matter of semantics, is that, okay, a restraining order can become permanent. And the reason that it can become permanent is that it continues to be necessary to insulate the, in order to protect from the prior abuse. At some point when it is no longer necessary to protect from the prior abuse, it should be terminated. So, I mean, a judge may continue it ad infinitum. A judge may not. It depends what the evidence is that the judge hears that would justify a continuance of the restraining order into the future. But I don't think I don't think the judge is wrong with her statement because of her use of the word necessary. In all of the cases, even the Latoya L. case, quotes cases that talk about the judge may, the judge may, the judge may. And what that is doing, it's showing that these judges have a great amount of discretion, which should only be disturbed if they're wrong as a matter of law. And the judge did nothing wrong as a matter of law in this case. I mean, if you look at, first of all, she didn't have any evidence presented to her. But secondly, you know, there was prior abuse. Okay, well, that's a given. We can't contest that at a hearing for an extension. We know that. And then there was just a presentation by her counsel. And on the other hand, there were actual objective defenses raised by
You're not citing the GAL report
right.
as...
Yes, for instance...
You are citing that as a defense.
I would not cite that as a defense. We don't, first of all, the judge asked for it, but there's no indication in the decision that, or in the ruling that she based her decision in any way upon the GAL report itself. What I'm talking about specifically is time, the factor of time. Now, the factor of time is not the be-all and end-all of a decision on a case like this, but the fact remains this incident happened in 2020, this hearing happened in 2024, and time can be a factor. But it can't be the only factor. And the fact of the matter is that it becomes more of an important factor and more of a relevant factor when there's a dearth of other factors that the court is given to consider. The second thing is, and it's uncontested and verifiable by the docket sheet, that the prior orders had been extended not for a year out, but for less than a year for small amounts of time each time. There was argument, if we intend to consider argument as any type of thing that could sway the judge, that mother had taken a fairly aggressive stance towards father in terms of bringing attempt to bring a restraining order against his new wife, attempting to alienate the children against him. The judge could find, not must find, that she was not one bit afraid of him at all. She was taking these actions. And again, we go back to the judge's discretion. Was the judge's decision so far outside of the ambit of possible results or was it an error of law that the decision must be overturned? And that's the question for the court. Unless the court has any further questions of me, I would
What
ask-
evidence was before this judge?
There was none.
So based on no evidence, the judge could vacate the order, terminate the order.
Based upon a present lack of evidence as to why the restraining order should be continued at this time, at this hearing, yes, she could. Thank you, Your Honors.
Thank you very much. I'd like to thank our court staff for all their assistance in putting on the sitting today. The case is submitted, and that concludes our session for February 11, 2025.
All rise.